have everybody's appearance here again, please.
Judge O.J. Mayorway on behalf of the people, or on behalf of the city of Roulette.
Just my clear on John Knapp on behalf of the defendant, Ms. Denise Maxwell.
Denise Maxwell.
And good morning, on Austin Basil, piece of info for that.
All right.
I got called Ms. Stan Barry.
Okay, good morning, ma'am. Your name?
Dan Berry, B-A-R-R-Y.
Raise your right hand, please. Do you solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God?
I do.
So is your first name Nan?
Dan, N-A-N.
And then last name is B-A-R-R-Y?
Correct.
Thank you very much. You can proceed, Mr. Mayorway.
Thank you, Your Honor. Ms. Barry, where do you live?
I live behind Ms. Maxwell,
What's your address?
25470 Kennedy,
In the city of,
Dearborn Heights.
and you said your next door neighbor is Ms. Maxwell, the defendant?
Yeah, she's behind me.
And what happened in June of last year that caused you to call the city of Dearborn?
On June 21st, I noticed somebody walking along the back fence on her side of the property, my existing chain link fence, and I wondered if the city was doing something. I spoke to Councilman Tom Wenzel on the 24th, and he said she was putting up a privacy fence.
She meaning?
Yes, actually. And so that was on June 24th.
And that was Councilman
Tom Wenzel.
Tom Wenzel.
Yeah. At the same time, there was some issue going on with DTE and a congresswoman involved. So I reached out to the city, expressed my concerns that this privacy fence was going in.
Why were you concerned?
Because he ran it along the chain link fence, which the fence does not determine the property line. Years ago, when we put up our chain link fence, the city required that we pull it in off the sewer line because there's a public or private easement with public access. And so they asked us to pull it in. And so all the neighbors knew that it was pulled in because the city told us.
By how much?
It varies because it's on an angle. My neighbor next door says it's at least 12 inches.
So you're saying that your chain link fence is on your own property,
Correct.
12 inches from the Maxwell property?
Correct. From from our survey initially and from what the city told us back then, and they said that there's like these little, I should be looking at you, sir, right? The little check marks on the sewer covers back there that you can see where they were stored and that. And if you looked at the plot line, it's a straight line back, so it doesn't go and cuts into ours. So we gave up that so that the city would always have access to the sewer. And they had gone out there. There were cases where they had to go tear things out. So on June.
Okay, let him ask the next question now. You ask your next.
So you were concerned, you called the city, what happened next?
I didn't, on the 27th, I sent Mayor Biazzi an email.
This is June 27th of 24?
Yes.
Okay.
And in that email, I expressed my concerns and explained the whole history that I just gave you. And so there was an email, I didn't know to print it off, but an email dated June 27th from Mayor Biazzi that he sent to Rick Watland and Carrie. There were a few others in there, Chief Stoll. And
No, we can't look at your phone.
okay, sorry, and what's on there? And in there, he said, please, look into this. That was on June 27th.
He said that to who?
The mayor said that to Carrie, Rick Watland, the building director, Carrie's boss. And so that before the fence went in, I had notified the city. And Rick showed up the 27th, thinking he was responding to the mayor's email to look into things. And the holes were already dug. And I said, Rick, you have my survey.
Okay, now, I'm not familiar with any of
I know, I'm sorry.
So Rick is the building director,
Correct,
Carrie McKinnon's boss.
right. And so
And so on. So you said he came out and saw that the fence,
the holes
were dug.
on June 27th, on a Thursday. And I said, you have a copy of the survey. And he threw up his hands and said, it's probably in the basement. We've had flooding. I'm not going to go look for it. So he said, produce the survey and I'll stop all this. So
Did you produce the survey?
I did, I had to go volume out of my basement, go through everything, I found the survey, and
When did you provide the survey to the city?
I sent it the 27th, and then I sent it again the 28th. I know, the mayor had his copy the 27th, I think.
Then what happened?
The fence went in on the 28th,
That's when on the 28th.
yes,
Very next day?
yeah,
That's important. We'll get back to that with Ms. McKinnon. So the fence went in on the 28th, and we've been dealing with it ever since, I guess, right?
I can't.
We've been dealing with it, you've been dealing with it ever
Yeah,
since.
there was like a sequence, I don't know if they provided you with, the mayor reached out on July 1st now and said that, Ms. Maxwell had failed to produce a survey. It was it was a hand-drawn thing. And then a letter went out, August 22nd. She was ticketed September 9th. And then we were told that she was gonna have a court date. And then the first hearing was October 24th, still no survey. And then
That was in Dearborn Heights, right?
Dearborn Heights, that's too important. In November 7th, we had another pre-hearing and still no survey. And then there was November 21st, again, no survey, but one was gonna be done. She couldn't provide the Roger Farina, the city attorney, a company name on the 21st. And
then finally, she ended up getting it on
yeah,
what
she
date?
did, yeah. But it was on the 21st that Judge Turfy and Mr. Farina recused themselves, saying that they were too closely associated with the councilman.
And Judge Plawecki also did that, right?
Yes, so everybody in the.
Okay, that's fine. So, all right, go ahead.
And is the fence still there in the same position that was?
Yeah, in fact, there's one portion of the fence, that is like, I think we measured like 7.5 feet. That I went to the city assessor and she said, Ms. Maxwell doesn't even own that property that's adjacent.
And you've experienced some issues in the meantime, while this case was pending?
Issues in regards to the harassment, intimidation type stuff.
Objection, Your Honor. That is relevance.
Your Honor, my client's been harassed by numerous people with regards to this matter, and she wanted to express herself about that. And I was trying to give her a chance to just tell the court what she's experienced in the meantime while this case has been pending, as potentially that can be relevant to Your Honor since witness harassment, witness tampering are.
Any further response?
Your Honor, this is a civil infraction. You're having a hearing with respect to a case size. This is what relevance does any precedent have to do with this matter?
I don't think harassment does, and I also don't think that whether or not there's political motivation involved in this incident does either. So my ruling is, we're not going to talk about the harassment, but we're also not going to talk about whether or not this is politically motivated. This is akin to the person driving 83 down I-75 saying, the police officer ticketed me, but not the person that was going 90. So I don't want to hear any of that. I'll ask you to move on to your next question.
I have no further.
All right, cross-exam.
Yes, Your Honor. Morning, Ms. Berry, Mrs. Berry. I just have a couple of questions for you, if you'd be so kind to answer.
Yep.
Thank you. You said you currently have a fence,
Yes,
a chain link fence?
yep.
And how close is this other fence to yours?
It varies. You mean the other fence being the privacy fence?
Yes, ma'am.
It varies from, right next to it to maybe 5 inches.
And you said you had a
You
survey?
guys have a picture of this?
I do not, Your Honor. My witness does, Your Honor.
So you're saying that her fence, ma'am,
Yes.
look at me a
I'm
second.
sorry.
Are you saying that her fence is a few inches from your fence, from your chain link?
one location, there's 7.5 feet that it's on my property, that is property that is not even, she doesn't even own the adjacent property.
You're saying that her fence extends 7.5 feet onto your property? Is that what you're telling me?
Yeah, here's the photo.
Okay, so he'll be able to bring that up on, you can bring that up on redirect, or you can inquire now if you want, Mr. Goff. So go ahead and ask your next question.
So I do have another question. You said you had a survey that you dug up out of your basement and brought to the city.
Mm-hmm.
Is that a yes, ma'am?
Yes.
Okay.
What year was that survey done?
For the record, you're refreshing your recollection by looking at a
Oh,
document.
I'm sorry.
That's okay.
Okay.
Do you need to look at something to refresh your recollection? Ma'am?
Yes, I need to refresh my.
Okay, so you can take a look and don't answer the question until you refresh your recollection, and then he'll ask another question.
It was required by the city of Dearborn Heights that we get it when we put up our what do you call it, the wire, the cyclone fence, and it was June 2nd, 1990.
Thank you. So June 2nd, 1990. You did also mention on the record that you were having some conversations. When was the last time you spoke to the city attorney, Roger Farina? Regarding this matter?
I haven't spoken to him in a while. I mean, spoken. The last time I spoke to him, I don't have a recall.
I do have some other questions for you. So you said that you saw the fence go up on the 28th, is that correct?
Correct.
And you said you saw the building director there the day before, the 27th.
Correct.
Okay. Did you speak to the building director while he was there?
Yes, we did.
Okay. And were you aware that the permit was approved?
He said, he said that the fence company had pulled the permit and that if anything was wrong, he would go after the fence company. And I said, the permit was pulled, I believe, in Ms. Maxwell's name.
And have you had a chance to see the survey that was done by Ms. Maxwell?
I have,
You have?
yeah.
Okay. And what are you not in agreement with on that survey?
I'd probably be in agreement with the survey company at least at 7.5 feet.
What's 7.5 feet? I'm sorry, maybe I'm a bit confused. If you just be so kind as to like.
You have her survey.
I do, yes.
This shows that her fence is in a location that's not even her.
Why don't, as long as we're talking about that, I'm gonna have to have that marked.
I can't hear you.
I'm going to have that marked. Let's mark that as an exhibit. We'll call it plaintiff's proposed number 1, even though you haven't brought it up. And we'll have that marked. I'm not admitting it at this point, counsel.
Yes, Your Honor.
But I think if she's going to refer to something, so why don't you hand that to my recorder? Tip.
There's the photo that shows it.
Okay, just the one you were referring to, you've handed to her, and I'm gonna have that marked plaintiff's proposed number 1.
And that's your survey, correct, from 1990?
Correct.
And you're saying that property she doesn't own, is that your property?
Yes. The property that's on that survey of hers.
Wait a minute, let's slow down.
Okay. Yes.
Wait a minute.
Okay.
I thought you said that this document wasn't the survey you had in 1990, it was her
It's
survey.
her survey, correct.
Yeah, so when was that done?
I had that, Your Honor. I was gonna bring that up in our
Okay,
case. But for the record, I'll bring it up in our case and I'll admit it
okay.
when I call my witness. Yeah, so I'm sorry, back to the question. Your survey 1990, you're saying that there's 7 feet of that property that's yours and not hers? Is that what you're telling this court?
I'm not clear on what you're asking.
You keep alluding to 7 feet. Are you saying that her fence is on 7 feet of your property?
Yes,
7 feet inside of your property?
yes.
So not.
She's saying 7 feet of the fence, I'm sorry to cut you off.
Yes.
Thank you.
6.
Okay, yeah. And 7 feet of the fence is on your property, and approximately how much of your property is 7 feet of the fence on?
I can't determine that because I can't see.
Are we talking inches?
I have no idea. I can't see
You can't see, I'm sorry.
beyond where the privacy fence is. I can no longer see where my property is.
Thank you. I don't
Her
have,
survey company is where it is.
I don't have any further questions for this witness.
Okay. Redirect.
So there's proposed exhibit number A right there, or one, I think Judge said. But you were trying to talk about it. You said that survey, her survey itself shows that it's on the wrong
Yeah,
part of the property. Can you explain that?
I'm not a survey expert.
Is that plaintiff's one?
Yes.
Okay, go ahead.
So this portion right here, which equates to this, so you can see.
Judge, can I have that as proposed?
Sure.
Thank you, Judge.
Mark that plaintiff's proposed to Tabitha. Just wait 1 second, ma'am. Wait till she marks everything up.
Look at them now.
Oh, you've had them both marked. You can go ahead and proceed.
Thank you. Go ahead and tell the judge what you were saying.
Okay, but if she's going to refer to those exhibits, they have to be admitted.
Your Honor, I'd like to move to admit.
Any objection, Mr. Goff?
No objection, Your Honor.
Plaintiffs 1 and 2 are admitted. All right, which one are you referring to now, ma'am?
So.
Wait a minute.
Show the judge.
You got to show me. Wait a minute, slow down.
Okay.
Slow down. What is that one, Mark, that you're referring to right now?
One.
Ma'am, listen to my question. Is that plaintiffs 1 or plaintiffs 2? Look at the bottom corner.
This is plaintiff 1.
Thank you.
Sorry.
Thank you. Now go ahead.
So this yellow section right here, her own survey company shows that it crosses a solid line, which is the property line between me and another neighbor. Her line goes here and there. Her fence comes in, dips in. She has it, see here, along there.
That's proposed, that's
I'm
admitted
sorry.
exhibit number 2.
Number 2, thank you.
So what you're saying is that her own survey shows that her fence is not on her property line, is that correct? And you said you had another picture of the fence for the judges?
Yeah.
This is proposed exhibit number 3, a picture, 2 pictures of the fence, 3 and 4, I guess we'll call them. I'd like to move to admit
No objection, Your Honor.
That's plaintiffs what?
3 and 4. There's other pictures for your,
Have you marked those yet, Tabitha?
Yeah.
oh, I'm sorry, I asked whether you marked as 3 and 4.
That's okay.
And I'm gonna have you, once they're marked and they're admitted, I'm gonna have you explain exactly what they are.
Okay, sorry. Okay,
Judge, you didn't object to their admittance. Are they admitted?
No, plaintiffs 3 and 4 will be admitted. You said no objection,
I
right?
did not object, Your Honor.
Thank you.
Go ahead. Steve. What are we looking at there?
so I'm over on here.
You got to show me.
I'm sorry. So this is the infamous manhole cover, which has always been told that we had to pull our fence in.
Okay.
So that we didn't obstruct the city. So her own company shows that her property is over here.
I don't understand what you mean by that.
According to the markings of the survey, what you're saying
Yeah,
is that manhole cover, when shown against the survey, indicate that it's not on her property, her own survey. Is that correct?
correct.
Your Honor, I'm gonna have to object to that with respect to the fact that she's not a surveyor. She can't read where where manhole cover is on a survey. She's got a survey in her hand. The document can speak for itself.
The document can speak for itself, Judge. She's letting Your Honor know what exactly.
Well, I'm
it
going to
says.
strike that because you're right, but you didn't object to any of the others. So all the testimony with regard to plaintiffs 1 and 2 is going to stand.
1 and 2, I have no objection.
Okay,
All right, that's.
so I'm going to strike that portion.
That's okay, Judge. I think that's it. I'm done here. Thank you.
Any other questions?
No further questions, Your Honor.
Okay, ma'am, you can step down. Thank you very much. I am going to have to go on to a couple of these. I apologize. So you guys can go out in the hallway and we'll take a 15-minute break on this. My apologies. Robert Lane Clark Jr., 25B, 148707. Thank you. And can I also have Alexander Groves seated at the table on my right? Katie Burns at the table on my right. Mr. Clark, come on up to the podium, please. State your name.
Yes, sir. My name's Robert Lynn Clark.
Can you turn that podium toward me, please? You're going to plead to impeding traffic, true?
Yes, Your
To
Honor.
that charge, responsible or not responsible?
Responsible, Your Honor.
The plea is accepted, improper lane use dismissed, 155, cashier in the hall to your right. Good luck.
Thank you, sir.
You're welcome. Alexander Joseph Groves.
Yes.
So, Mr. Cole. Jan.
I was just going to write something about it. Somebody just hired right on the Charlie, Gabriel Smith. Just hired right. I'm not sure why he's coming to say.
See, Mr. Radford, you have Michelle Cormier, 25 DCCR 0153.
Yes, ma'am.
Morning.
Mr. Coleman's case. I think he's in trial. isn't
He is. Somebody handle this for Mr. Coleman.
he? Yes, Judge, we got stuff. Hello, Michelle.
Good morning, ma'am. Are you Michelle Cormier?
Yes, ma'am.
And Ms. Cormier is charged with the offense of murder in cause number 250153. And Mr. Radford, what is the announcement?
Judge, I have a conference next week with my expert in this case that will give me insight as to where we go from here. I should be able to announce if I have one more.
Okay. Any notes or issues from Mr. Coleman? So we'll reset it one more time to give you an opportunity to do that, and then we'll get an
I'll be ready.
announcement at that next court
I'll be
date.
ready then.
All right, thank you. You can go back with the bailiff. Mr. Rojas, you've got, yes, sir. Bryce Bordeaux, 250444. Good morning. Good morning. Sorry, am I messing you up now? You can put it in because it goes.
Good morning, Your Honor.
Good morning.
When he was asking for a reset on that case, he was just hired on, so Gabe's all, I'm over it.
Okay. We're going to reset Gabriel Smith. It was Mr. Rojas's, but Mr. Kimler's been hired. Yes. Good morning, sir. Are you Bryce Bordeaux?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here we go.
Mr. Bordeaux, you're charged with the second-degree felony offense of robbery, and that's from March 18th of 2025, and that's cause number 250444. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them, that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine And then we would wait for the PSI and see if there was any type of recommendation for safe P or treatment, and then I would make that determination. Is that your understanding? Also, do you understand if you are not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Bordeaux is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. Then we'll come back at a later date for sentencing. All right, thank you, sir. You can go back with the bailiff.
That's all I have.
Yes, sir, thank you. Oh. Okay. Mr. Nix?
Yes, Your Honor.
You've got Michelle LaChasse.
Yes, Your Honor.
That's all that stuff. Good morning.
Good morning. How are you, Judge?
Good. Good morning. Good morning, ma'am. Are you Michelle LaChasse? And this is cause number 22-39304. Ms. LaChasse is on probation for abandoning or endangering a child. It's a state jail felony. And that probation was for a 3-year deferred probation, October 17th of 2022. Has that been extended? Okay. So obviously, if we'll see what we do today, but if there's going to be safe P, I think that would be a requirement for me to do that. So I received an administrative hearing on April 30th from Mr. Ruiz with some issues that have been going on with regard to Ms. LaChasse allegedly going to the Sky Bar Lounge, failing to adhere to the curfew, failing to adhere to mental health services and treatment plans, remaining compliant with medication, admitting to drinking, and also admitting to trying to locate drugs as well. That hearing recommendation was to continue supervision and request safe P, which was agreed at the time by Ms. LaChasse. I signed off on that and ordered it. Mr. Nix has filed a motion asking that I reconsider that. I have asked probation for kind of an update in their response to that, as well as the state, who said pretty much it's up to me and probation and everything else. So it's my understanding, Mr. Nix, that Ms. LaChasse is wanting to do some kind of local inpatient treatment.
So, Your Honor, if I could briefly just kind of give a little bit of a recap. She had her medication switched on March 11th and March the 20th. And shortly after that, if I can present this, I've shown a copy to the district attorney's office this morning. It showed that they made a major medication change, took her off Seroquel, put her on Prozac. She immediately started having issues with the Prozac. She's still having issues with the Prozac. She's taking the Prozac at the jail. They're giving it to her. She's having issues. What we've done is we've spoke to Baptist hospitals. I have her mother and I have her fiance here. We have documentation that she would be accepted into inpatient at Baptist Hospital. Also have a letter from her doctor.
But that's just a 5 to 7 days.
No, they can actually keep her inpatient for up to 30 days, Judge, and then they have an outpatient program that could continue after that. If I could present this is a letter from her doctor that kind of underlines her very exacerbated issues. What I'm asking the court to do is not to exactly undo the safe P. What I'm asking the court to do is hold the safe P in abeyance give her a chance to do the inpatient Baptist, make sure that she's on the right medication. I presume that a major medication change is about to take place due to the fact that she's having such issues with the Prozac, and we reconvene after she's completed an inpatient stay, whether it be 14 days, whether it be 30 days. I'm assuming it'll be 30 days based on what the fiance's talked to with Baptist. It would come at no cost to the taxpayer or to probation. We've already cleared it with her insurance. She's stayed there before, and insurance covered almost 100%. I'm asking the court to just hold the safe P in abeyance until she can do the inpatient treatment. We reconvene in 30 days and see how she did in the inpatient treatment. And then depending on how the reports go, how everything that I turn over from her inpatient stay to both probation, the state, and the court, you decide if safe P is still in her actual best interest at this point. We understand that safe P is also a blessing. She could have been sentenced to state jail time. We're not underscoring the issues. We're explaining to the court that this is a mental health issue caused by a major medication change that's documented. Her issues follow immediately after this, and she's still on the Prozac, and she's still having lots of problems in the jail on the Prozac. We're asking that we just hold this in abeyance. I'm not asking the court to undo it, take it away, put her back on regular probation. I'm not asking for that. I'm asking to hold it in abeyance, place her, allow her to be placed in the inpatient.
But we don't, do we know, is it up to the hospital how long she stays?
I believe so, Your
I can't
Honor.
order some
Correct.
certain amount of
Correct.
time.
And however long that is, if the court feels that it's not long enough, we can reconvene and I can show you the records at that point and we can make a decision from there. But Baptist has told the family that it would be up to 30 days and then they have an outpatient treatment that can continue after that. Now, of course, we won't know if that's appropriate until we see how she does in there, but it's pretty clear that this is a medication change that caused this behavior.
Mr. Nichols?
Judge, the main hesitation on our part is that she agreed to safe P and now wants to do things on her terms. I think safe P is where she needs to be based on the relapse and the violations she had. And I want to bring the court's attention, when she was first put on probation in 2022, she was ordered ISF. Didn't want to go, went to a private inpatient program in Houston, in Harris County, which she was discharged unsuccessfully from. So it's almost like we're rewinding the same script as before, and it obviously didn't work then.
I didn't see that.
I don't think it's contained in the admin. I think Mr. Rudes can testify to that, Your Honor, if you want more detail. He informed me about that this morning.
Okay. Do you have any disagreement with regard to what happened at the beginning of probation that they're talking about, Mr. Nix?
I'm not sure that I was a part of that, so I don't know that I can speak to that. What I can speak to is that they made a major medication change that immediately caused these issues. Safe P is a wonderful program that's helped a lot of people. I don't know that it's fine-tuned for her mental health issues that are causing the issues right now. I think it's a fantastic program, and I still think she might end up there, but I think if we get her the right mental health treatment and get her on the right medication, she's much more likely to be successful in Safe P if she has the right medication and she is of the right frame of mind.
The special needs Safe P facility, do they adjust medications and things like that? Yeah. I think based on what I know now from the beginning that I ordered or agreed or whatever happened with ISF, and then agreed to allow her not to do what everybody else thought was appropriate, go to her own choice, and successfully discharged from that, and here we are having the same problem. So I'm not going to adjust that order.
Yes, ma'am.
I am going to order the special needs. It's special needs safety. It's not the regular one. It is, the whole purpose of it is to treat both things. And so that can all take place there, and I think that would be better for her and for our community. In addition, I am going to, because of the issues in the administrative hearing, the fact that a motion hasn't been filed, the length of time, I think, obviously is an issue. And so I am going to also at this time order that Ms. LaChasse's probation be extended by 2 years. That should give plenty of time to get through the program, get through aftercare, make sure everything is going like it should be, and then hopefully get off this probation without a conviction or going to state jail. All right, I know it's not what you want. I hope you take advantage of it. However, it's a good program. You can talk to them about medications and get stabilized before you get out and get on aftercare. Okay, thank you, Mr.
Thank you,
Nix.
Judge.
Thank you,
Thank you,
Your
Mr. Ruiz, for being here as well. There's really not I think all that's probably can be thrown away. Mr. Nix, you also have Ebony Broussard.
Yes, Your Honor.
3 cases. There is no paperwork or agreement on this, or,
We've got something cooking.
okay,
So, Your Honor, Ms. Malfino.
let's wait for
I'm
Ms.
sorry.
Broussard. That's okay. Good morning, ma'am. Are you Ebony Broussard?
Yes, ma'am.
And Ms. Broussard is on probation in cause numbers 19-32518, 19-32806, and 21-36615 for the offenses of escape while arrested, assault on a peace officer, and possession of a controlled substance. There's been motion to revokes filed in all 3 of those cases. And Mr. Nix, what is the announcement?
Your Honor, I've spoken with the state. I think we have something in the works. I think we'd both like a 2-week reset. And I think in 2 weeks, some offers that we made to the state to try to resolve these issues will be made whole at that time. And I think this will be worked out at the 2-week reset.
Any issue, Ms. Malfino?
Judge, I have spoken at length with Ms. Johnson, who has worked with this defendant for a long time now. Of course, respect her position ultimately in that she is the one who actually works with her. There are quite a bit of arrears due in this case. Ms. Broussard has been ordered previously to pay those with forms of income such as her tax return, et cetera. She has been defiant in doing that to the probation department. Mr. Nix indicates that she, via her family while she remains in custody, is able to do that in the next 2 weeks, and I'd like to reconvene at that time to maybe see where we are. Our position in the alternative will probably be ISF cognitive. In fact, if she does not get that paid, we may just go ahead and proceed with the motion. We'll be ready to do it on that day.
Okay, sounds good. Thank you for being here, Ms. Johnson. We'll reset the case for 2 weeks.
Thank you, Judge.
Thank you. Ma'am, you need to remove your hat, or you need to remove your hat. Or sir, I can't tell, I can't see your face, whoever.
Check your phones, make sure that they're in off position.
See, Mr.
The service, you'll be actually in the courtroom.
Thank you. Mr. Burbank, you've got Jerry Jenkins.
Judge, before we bring him out, may we just discuss with the court?
Yeah, just hold on. both ready on Jerry Jenkins if there's not some agreement?
Yes, Your Honor, we would expect to be number one.
Okay, Mr. Burbank?
I always expect to be number one, Your Honor.
Okay.
Just due to the age.
So, yeah, it's definitely, so I'm gonna, wait to hear from y'all. I would make it as early in the morning as possible, you know, before 10 o'clock, because we'll have to get both of you over
I
here.
can be here at 6:30 in the morning. before you pick.
Let's do it. Don't dare me. So, yeah, let me know and then we'll work that out tomorrow. Otherwise, it will be numbered, so we don't need Mr. Jenkins. Mr. Burbank, what about, do you want to go ahead and announce on Terry Rose?
Yeah, we could, Judge. Somebody get Mr. Rose?
Yeah. I know. It's our first day. You did video. Oh, no, no one asked.
Okay, I'm just making sure.
Was that one, the one that just left? Okay. Good morning. Are you Terry Rose?
Yes, ma'am.
And Mr. Rose, in cause number 241369, is charged with the offense of murder. There was a request for a competency evaluation that was done by Dr. Grapon. I'm going to take judicial notice of the court's file. We've received that evaluation dated May 23rd of 2025. Dr. Grapon, after that evaluation, makes the finding that Mr. Rose is currently competent to stand trial. Is there any other evidence with regard to competency? Mr. Burbank?
Thanks, Judge.
No, Your Honor.
Then at this time, I am going to find that Mr. Rose is competent to stand trial. Mr. Burbank, announcement?
Your Honor, as you are well aware, I'm the second one.
Right.
I just need one more announcement, 30 days or 40 days, and we may be able to.
Okay. Any issue with that, Mr. Nichols?
No, Your Honor, we're just, state's ready to proceed.
And I appreciate you getting up to speed as quickly as possible. Looks like we've got an investigator involved and you've taken care of that.
We do,
So,
and I was out, I provided him information, and he's helping me with this, and so once I cover all my bases and get up to see the district attorney, we'll be able to take care of this now.
all right. What I'll do to make sure your investigator, you have plenty of time to get up to speed, is reset it 45 days and expect an announcement on that date.
Thank you.
All right?
Maybe
Thank you.
excuse to that time.
Yes, sir.
Thank you, Judge.
Do you want to go ahead and take care of Bryce Thomas and then visit? Okay. Bryce Thomas?
Your Honor, we're
Would
going
y'all,
open.
hold on a second. Are y'all pleading to the indictments? Are there some
There's-
lessers? And
yes,
can I
there's-
get all four of those, please, printed out?
The unauthorized use is being dismissed.
Give me just a second while they print out the ones that are being, just the four that he's pleading on. I need,
Got these right here. if that's what you need.
everything, all of them except 0534. Good morning. Are you Bryce Thomas? And Mr. Burbank, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor. We're going open on each case, and the aggravated sexual assault is being the lesser included indecency by exposure, which is a third degree.
So is,
Did you sign it? Did not.
We can do it, y'all can get it done as soon as I'm finished. I'll go,
Completely about the registration.
I'll go through it with them. I just want to make sure, because of the agreement for the lesser in that case and for anything to run concurrently, is that the plea bargain agreement where he would be waiving his right to appeal?
And also they're
The dismissal.
dismissing the UUMB.
Gotcha, okay. Give me just a second, yeah.
And the lesser included is December 1st, is a
Third. Oh, 0354's been dismissed, I think. Or 0534, whatever I said. Okay, Mr. Thomas, in cause number 24, DCCR 0389, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 31st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In cause number 24-0390, you're charged with a third-degree felony offense of possession of a prohibited weapon from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In cause number 24 DCCR 0391, you're charged with a state jail felony offense of theft of a firearm, and that's from January 30th of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And then what is the reduction to?
Yes, indecency exposure, third-degree felony.
In cause number 24, DCCR 0392, the state has elected to proceed on the lesser included offense of a third-degree felony of indecency with a child by exposure, and that's from November 9th of 2023. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand them? And I want to make sure you understand there's kind of a partial agreement, and that agreement is that the state is going to dismiss cause number 24-0534, which is an unauthorized use of a vehicle. They are agreeing to that lesser included offense of the indecency in that case. And they're also agreeing that if anything that I sentenced you to, if it's time in prison, would run concurrently. There's not a specific agreement with regard to any time or any outcome, only those agreements with regard to the dismissal of the case, the reduction in the other case, and the fact that they'll all run at the same time. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, in that indecency case, do you understand that you will be required to register as a sex offender? And Mr. Burbank will go over that more with you today, and there's a document you need to sign today with regard to that. And do you understand that as well? State tenders number 1 in each case.
No objection, states one in each case, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each of your cases to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get a pre-sentence report done. That'll give me more information about you, your cases, and we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Burbank. He will present it to me on your behalf when we come back. All right? You can go back with the bailiff.
Maybe excused from that.
Yes, sir. And I'll give you a minute to talk to
Can
Mr.
someone
Ramon.
Send it back to a computer.
Send what back?
I think we have to send back so I can do the admonishment for the sex offender. I know, but can I get back into it?
In the case, I think you can.
Okay.
Just get back into that case, I think you can.
And I'm going to go
Oh,
out.
she's gonna send it. Yeah, make sure they don't take Mr. Thomas yet until Mr. Burbank goes over. He's got to sign one more paper. Thank them. Is Mr. Franklin here?
Yes, Your Honor.
Good morning. That's on Juan Sanchez. Good morning, 18-30854. How are you today?
Just fine, how are you?
Good, thank you.
So, yeah.
Anna, what were you asking?
It was, Lawrence Thomas, 392 about Joseph Burbank.
Good morning. Are you Juan David Sanchez? And Mr. Sanchez is currently on probation for the offense of driving while intoxicated, third or more. A motion to revoke was filed with the allegation that there was a new offense of driving while intoxicated from April 15th of this year in Wharton. Is that Wharton County or anyway, it's in Texas. And then also that on April 15th, 2025, he was driving a vehicle that was not equipped with an ignition interlock device and that he failed to abstain from the use of alcohol. Mr. Franklin has filed a motion asking that I set a bond. There's currently not a bond on the motion to revoke probation. Do you intend to call your client as a witness or no? Or,
Only if necessary, Your Honor.
go ahead and I'm trying to find, give me just a second. I'm looking for the old PSI.
I have my copy if you need it, Your Honor.
This one may be old enough where it didn't get,
It may be so old, like back then, they probably weren't.
It was 2019.
okay. All right, you can go ahead, Mr.
Your Honor, we
Franklin.
have not been provided with a copy of the old PSI. That was not produced to us. So that was one of the issues I think that he's addressing. We also supplied
Mr. Nichols,
right up, I'm sorry.
go ahead.
We supplied, we filed with our motion about a dozen letters in support.
And I have received those and take judicial notice of the court's file that includes those as well. Thank you.
Thank you, Your Honor. In assessing whether Mr. Sanchez is a flight risk, I think the support from his community, from his family, helped provide evidence that he's not a flight risk. So the court should then turn to the prong of whether, of what threat he may pose to himself or others. In this case, the underlying offense was 2019. The motion was filed based on a violation, true, but there were not other violations as far as not reporting or failing other tests up until now. So that's been effectively 6 years that he's been compliant. We'd also like for the court to take note that the other offenses that are mentioned go back as far as 1992 to 1995, 2001, et cetera. In other words, it has been, in some instances, decades since those offenses occurred. And although we're not downplaying the severity of what Mr. Sanchez is currently charged with, we do think the court should take into account, as regards the threat to himself or others, the fact that the other causes are, in some instances, over 30 years old.
What's the status of that case in Wharton? Does anybody know?
Your Honor, it is my understanding, and I don't represent him on that case, but my understanding is that it is pending because this one fell first in the queue, so he was sent here first.
Okay. So they're going to wait for us to see what I do, I
That
guess.
is my understanding, Your Honor, but again, I don't represent him on that, but that's what I could glean. I spoke to a lawyer that he conferred with there, but he did not end up hiring that lawyer, so he couldn't speak,
Okay. All right, Mr. Nichols, what's the state's position with regard to a bond?
Judge, my main concern is him driving a vehicle that doesn't have an interlocks. We have no idea how much driving he's done. It sounds like the only reason we found out about this violation is that he got caught. I doubt that this is a one-time event of driving his wife's vehicle without an interlock. And so to protect the community, I'd ask that if the court does set a bond, that it be high enough to protect the community from his repeated driving while intoxicated.
Your Honor, may I respond?
Sure.
First, speculation as regards any other instances is probably not admissible. But secondly, there are measures that the court can take in assigning bond conditions to monitor Mr. Sanchez in such a way that he...
But he had probation conditions that were meant to monitor him.
Your Honor, as regards whether he's drinking, for example, there are SCRAM devices and other devices that constantly test for alcohol in the system. The SCRAM device, for example, tests every half hour.
Yeah, so here's where I am on this. Mr. Sanchez had at least, this is his fourth conviction that we know of for a DUI. I know there were some other arrests that we didn't have the disposition. Looks like, at least according to some of the information I've received, that there's been 7 or 8 arrests. This was a cap.
Including those as well, Your Honor.
Okay, that's overruled. They think with regard to setting bond under 17.15, I'm able to take into consideration everything that is at my disposal. And in fact, I'm required to take into account everything that is at my disposal with regard to prior offenses, with the most recent bail reform, as well as the ones from a couple years ago. So I guess my worry isn't necessarily the reporting or him fleeing. My concern is for the safety of the community. And this was a cap of 8 years when I gave him this probation, probably against the argument of counsel from the state, and gave him this opportunity. He's on probation, commits another. We're lucky we're not here for an intox assault or even worse. I am going to deny the motion for a bond at this time. If there is any likelihood at all that I would leave Mr. Sanchez on probation, it would absolutely be with some type of treatment. And so I'm not going to allow him to get out and even with the scram or anything else and put the community in danger. All right, we'll get it set for an announcement within about 30 days or so, and then we'll see where we get on the case.
Thank you, Judge.
Thank you, sir. You can go back with the bailiff.
Your Honor, may I be excused?
Yes, sir, thank you. Oh, that's okay. Got it. Today's the 10th. See, it's Mr. LeBlanc. Oh, good morning, Mr. LeBlanc. You've got Linton Arsenault. Are you ready to make?
The prosecutor's COVID. He's not here, and I need to talk to him about something, so I don't know.
Okay. Is there something Mr. Hoffpower is not available this
No,
morning.
no, Your Honor, he's not in this morning.
Did you try to visit with him before today?
Yeah, we talked, I didn't know who would be here. We talked yesterday.
All right, I'm going to reset Mr. Arsenault for 2 weeks to give Mr. LeBlanc some time to visit with Mr. Hoffpower again. Make sure you visit with him before that next court date, just in case something happens, since that way he can make some notes for the district attorney. All right, you can go back with the bailiff. You've got Corey Flemings.
Yes, can I have one moment?
Sure. Sure.
I just set the registration if you want to go over at sentencing with him.
I don't really have to. I just need it signed by him. Thank you very much. I see it just came through. Mr. Cole, you've got Leonard Eilbird.
Yes, Your Honor.
Oh, that's just setting a hearing.
Oh, I have, though. He didn't send me an order.
Okay. Okay, that's okay. I might write on, let me see what I'll need something. Good morning, Mr. Cole.
Good morning, y'all. How you doing?
Good, how about you?
Great, great, great.
All right, are you Leonard Dale Adelbert?
Yes.
And this is cause number 1625968. Mr. Adelbert is on probation for driving while intoxicated, third or more. A motion to revoke has been filed, and Mr. Cole has filed a motion asking that I set a bond in this case.
Yes, sir.
And it looks like the allegations from that motion are that Mr. Adelbert, while on probation, allegedly committed the new offense of driving while intoxicated, third or more, January 9th of 2025 in Chambers County, Texas. That he left Jefferson County without permission. That he drove a vehicle that did not have an interlock device on it. That when he was stopped, the allegation is the intoxilizer that was administered provided breath samples of 0.108 and 0.115 and behind in his fees a little bit as well. Mr. Cole?
Well, Your Honor, I think since the time that Mr. Otterberg was put on probation in 2017, up until this latest incident, his mental capacity has changed dramatically. He's been diagnosed with Alzheimer's. He's on the verge of his nerves inside of his brain have shrunk. So on top of the Alzheimer's, he's has the possibility of having a stroke. So I think that this is him not remembering the conditions, and his wife is here that can, his keys, you're taking his keys. We do have paperwork that I gave to counsel that can, from the doctor showing that he does have Alzheimer's. He was diagnosed in March with Alzheimer's, and the nerves in his brain are shrinking. Your Honor, he's unaware that he even violated the condition.
Well, that makes it even scarier for me.
That I know it does, but we're asking that we get him out, and his wife is gonna take care of him and make sure that he doesn't drive that car anymore. Take the keys. Now that we're aware of.
Why don't you, if you want to put on a witness, that might help.
I'd like to call Gwendolyn Brown, please.
Okay, Ms. Brown, come on up, ma'am. Do you have some documentation? Good morning, ma'am. And your name, what was your first name?
Gwendolyn.
Gwendolyn Brown. And Ms. Brown, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Go ahead, Mr. Cole.
State your name for the record, ma'am.
Gwendolyn and Albert.
Yes, ma'am. And how long have you known this gentleman right here?
He's been married 13 years.
13 years. And when did you start noticing deterioration in his mental capacity?
Back in December last month, last year, 2004.
And I guess another question I want to ask you is,
Can you speak up, please?
what are you willing to do to ensure that Mr. Heidelberg no longer has access to his vehicle?
I will take the keys from him. He will not drive anymore. Never.
He already had it.
He already had the keys. He can't drive anymore. He will not drive anymore.
That's her car. That's her car.
Oh, I'm sorry.
So, he will not drive anymore. I will take the keys from him, and he will not drive.
And do you think that in the situation that happened in Chambers County, do you think that he was aware of the conditions of probation that he was violating at the time?
No, he wasn't aware because his probation officer told him that she was done with him. So when you say you're done with somebody, that means you're done with him. You thought he wasn't on probation anymore.
So there's a lot going on upstairs, Your Honor. I don't want him showing back up in a red suit. I know she can care for him outside of this facility that he's currently in right now, which is in jail. We have a court case in Chambers County that we would like to be at. And I don't think that he was intentionally violating probation. I think that he, at this point, his mind is.
He get lost all the time.
So he's getting lost. He doesn't know whether he's coming or going. And I can have a conversation with him right now, and he'll forget it in the next 2 hours. So, it's one of the
Thank you, ma'am. You can have a seat.
I just want to say one more thing.
Yes, ma'am.
When he was in jail in Chambers County, the probation officer told me to bring him to her as soon as I get him out of jail, right? So I brought him to her, and then she called his name, and I was going upstairs with him, and she said, "Miss Heidelberg, you have to stay downstairs." So she went, she said, "Only me and my supervisor need to talk to him." So my supervisor talked to him, and when he came back outside, I said, "What did she say?" He said, "Nothing." She said, "Go home." But she had told him to go turn himself in to Jefferson County.
Okay.
He didn't remember by the time he got back to the court.
Okay.
So he would have been in jail.
Right. Thank you, ma'am. Ms. Malfino, based on,
Obviously, I have the same concerns with the court based on the representation of his wife, that he won't be driving. That gives me a little bit of comfort. I did speak myself with Ms. Hunter. I know she's probably just told him what the rules are, and maybe he doesn't understand them, but I know she hasn't been combative with him. She initially told me she doesn't oppose him being a bond. I don't know if she's aware of these medical conditions, but again, I'm concerned with the driving factor. And obviously, you couldn't go somewhere like mental health safety or anything with that.
no, not with that diagnosis, and I don't think with that diagnosis either.
Right.
Let me look at something else. All right, so what I'm going to do in this case is set a bond. I'm going to set the bond at $5,000. I'm going to order that a condition of that bond is that Mr. Heidelberg not drive ever. And I'm doing that on the representation that the keys will be taken away, hidden, whatever's necessary. And so I'm looking at you, ma'am, that you are giving me that representation to make me feel comfortable that he doesn't get the keys somehow and drive. So just sticking them in your purse or sticking them in a drawer with this type of diagnosis is not going to be good enough. I'm going with your assurances that you're going to take care of that. Obviously, you don't want anything to happen to anyone else in the community as much as I don't. So I'm going to do this based on the fact that you're giving me those assurances. And then, obviously, there will not need to be, if there's already an order for an interlock, I will allow that to be. Is there an interlock?
Yes, Your Honor. But he's done.
Well, I know we want him to be done and we're saying he's done. You're able to drive the vehicle with the interlock, correct?
I can't breathe. You talking about, breathing?
Y'all don't have, how many cars do y'all have?
I have one car.
Okay,
His car is gone.
it's gone.
Right.
Okay, so I won't require an interlock on her vehicle, so that, if he doesn't have, if that's gone, then we're fine with that. Any other condition other than the no driving and her assurances that you can think of, Ms. Malfino?
No.
Okay, all right, we'll reset it for an announcement on that, MTRP.
Well, may I just inquire, Judge, before that hearing, is it Mr. Giles, Mr. Cole, your representation to the court that you believe at some point in time, your client will be able to enter pleas of either true or not true to this motion, or do we need to make some other type of arrangements?
I believe that he'll be able to make pleas are true or not true.
Okay.
Yes.
Once you have more time to visit with him as well, if there's an issue because of the diagnosis with regard to competency, we might have to try to just see where we are on it all, okay? All right, thank you. You can go back with the bailiff.
My excuse, Your Honor.
Yes, sir. Mr. Wilkerson, you have Shanna King. Is today your birthday? Happy birthday.
Thank you very much.
I would sing, but you don't want me to do that. Trust me. The gift is that I'm not going to.
I say the same thing to people. I can't do it. Love to do it, but
Yeah.
every now and then I torment people at nightclubs with a little karaoke spill.
Y'all have got second and third marked off on this.
So, Judge, the tablets won't let us erase.
Oh.
So,
You have to push the
I
button.
tried both buttons and.
So it should be second.
It's a second.
It's a
Okay,
second.
I got it.
Yes.
All right,
Sorry
ma'am,
about
that's okay. Are you Shanna King?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. King, in cause number 250295, you're charged with the second-degree felony offense of burglary of a habitation, and that's from December 13th of 2024. And how do you plead to that charge?
Guilty, ma'am.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. King is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Wilkerson. All right, good luck to you, ma'am. You can go back with the bailiff.
Okay, thank y'all.
Thank you.
Be excused.
Yes, sir. Mr. Burbank, are you ready on the sentencing on Johnny Jacobo Ramon?
Yeah.
Good morning, ma'am. Would you, Ms. Burge, would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English, so help you God? Thank you. Good morning. Are you Johnny Jacobo Ramon?
Yes.
And Mr. Ramon, you were previously in court and entered a plea of guilty to the second-degree felony offense of accident involving death. And that was a plea agreement of a cap of 15 years in prison. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Defense has. Yes, Judge.
Are there any additions or corrections?
No, Your Honor. Not from the state.
Mr. Burbank, you may proceed.
Your Honor, this is a tragic accident. If you read the factual basis, which I know you did, person was walking across the street at nighttime, and cars swerved, and my client actually hit him. As reflected by the charge, he failed to stop. He panicked, as in reference to his version, that is on page 1, and then was stopped up in Lumberton. He's been employed. He has family up in Woodville. He's been employed. He's got one problem. He is not a U.S. citizen. I would be arguing for probation in this case, but it is my understanding that there is a hold on him by immigration, and that he probably will not, if he got probation, he wouldn't be released. He has 2 prior DWIs from Tyler County that were taken care of. At the same time, what you receive, basically time served, 90 days jail. The intoxication charge that I believe is from Hardin County was when he was arrested, and that's been dismissed or rejected by them. And probably because we're down here, they probably did it. Your Honor, I asked for there's a death involved, and I would love to have the minimum in reference to penitentiary time, but I'm asking for mid. I think that 15 is probably too harsh, and that's my opinion, especially in light of the facts and circumstances of this, in which the person was walking across the street at the time and being blocked by other vehicles, and other vehicles had to get out of the way. But he was definitely wrong in not stopping, and he was intoxicated. I would ask for anything less than the 15, because I know where he's gonna go, and that's a sad thing, but he's not here legally. And I don't know if he would like to address the court.
Sí.
Yes, sí.
Go ahead.
Quiero decir que lo siento, que si lo hubiese visto, yo me hubiese detenido antes para poder auxiliarlo, pero pues.
Hold on.
Judge, I'm so sorry. Had I seen him, I would have stopped and helped and rendered aid.
Pero pues había un carro con
Hold on. Hold on. So are you telling me that you didn't know you hit someone?
¿Me está diciendo que usted no sabe que le pegó a alguien?
No, sí, sí, sí.
I did know.
Okay.
Y pero pues había un carro enfrente y yo no lo pude ver
There was
antes.
a vehicle in front and I wasn't able to see him on time.
Okay.
Pero pues quiero decir que lo siento. Que
I want to say that I'm sorry.
si pudiera volver el tiempo lo haría, pero
But if I
sé
could
que
go back in time, I would go back and
soy
help.
el culpable.
And I know I'm guilty.
Okay. Thank you.
I just have one question up here. What were you doing for work?
¿Qué estaba haciendo de trabajo?
Estaba en el roofing.
I was a roofer.
And how long have you been, how long have you been in the country?
¿Cuánto tiempo has estado aquí en los Estados Unidos?
14, 15 años.
14, 15 years.
And have you always had a job?
¿Siempre han tenido un empleo?
Sí.
Yes.
And you do have a family?
¿Y si tienen familia?
Sí.
Yes.
Thank you. Mr. Smith?
Judge, we would argue for the max sentence in this case under the plea agreement based on the fact that when he struck him, he knew that he struck him. That was evidenced by the phone calls. The next day, he knew he hit a person. When he was stopped in Koontz, which is a long way from the accident scene, he told the police when they noticed the damage on his vehicle that he had struck a deer. They, either through dealing with him before or suspecting that he was lying and knew he was intoxicated, went all the way back to the county line looking for a deer that had just been struck. And only because they were diligent in doing so did we even know that he had committed this particular crime. He knew he committed the crime. He lied about it. He has an issue with alcohol. He's here in the country illegally. I would direct your attention to the jail report in this case and how he's acting, showing disrespect for staff as well as masturbating in open bunk. We ask for a 15-year sentence in this case.
Mr. Jacobo Ramon, obviously the facts of the case are terrible. The fact that you didn't stop. The fact that you were intoxicated. And in addition, and I'm not even sure that when you were in our jail for some amount of time, there was a requirement that I release you because of the amount of time that had gone from the time of the offense while you were sitting in custody. I did that, and then you didn't show up. You are here illegally and have now killed someone. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. And at this time, find you guilty of accident involving death. Sentence you to 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. It is in Spanish. I advise you to read that. If you are ever back in Texas legally, you will not be able to possess a firearm or ammunition. That could lead to more charges against you. All right. Thank you. You can go back with the bailiff. Thank you, Mr. Burbank. Thank you, Ms. Burge. Mr. LeBlanc, are you ready on Corey Fleming's? Good morning, sir. You're Corey Flemings.
Yes, ma'am.
And Mr. Flemings has two cases, cause number 24-2144 and 24-2145, set for trial to begin with jury selection on Monday, the 23rd. And what is the announcement?
We'll be ready, Your Honor.
All right.
State's ready, as far as I'm aware, from Mr. Coleman, Judge, I would ask that Mr. LeBlanc make a request for the media if he has not done so already, since we have a bit of time in between.
Okay. Have you asked for and received the media?
I believe this is the one, yes, I've asked for it, but I haven't received it. If I have it, I'll have to check if I have it, if all this, but
It's
at any rate.
okay. Well, but if your client hasn't seen the videos or any type of media with you, then how do you know for certain that this is what is the appropriate end game? Because he hasn't seen, I would assume in an assault on a peace officer, there's body cam footage that might affect what agreement there is. Do you know if that is, can that get ready today?
Yes, Judge, it doesn't look like it was marked as requested and received, but I can follow up on it.
I want that done today.
Yes, sir.
I want you out to see Mr. Flemings by tomorrow
Yes, sir.
to review that with him. And I want to know by tomorrow at noon that it has been done and that in fact this is what Mr. Flemings wants to do, is go to trial after seeing that. All right? I want to hear from you at noon tomorrow. Okay, you can go back with the bailiff. Done. Done. Mr. Lewis on Christopher Falk. And this was, he was evaluated.
He's evaluated. He's competent.
Okay. Good morning. Are you Christopher Falk? Yes, ma'am. And this is cause number 24-1891. Mr. Falk is charged with assault on a public servant. There was a request to have Mr. Falk examined for competency to stand trial. Dr. Grapan did that evaluation. I've received that report dated May 30th of 2025. It has the finding that Mr. Falk is currently competent to stand trial. Is there any other evidence with regard to competency?
Nothing.
No, Your Honor.
All right, then based on that, I am going to find at this time Mr. Falk competent to stand trial. And do you need some time for an announcement, or are y'all ready to make an announcement today?
A little more time, Judge. I have talked to him a little bit since we've gotten the report back, but I think we need to talk to state a little more and see if we can get it worked out.
All right, I'll reset that one more time, and then we'll see if we can get an announcement at the next court day. Is that your computer? That's okay.
I need to get the bailiff.
All right, we'll reset it. We'll get an announcement at the next court date. You can go back with the bailiff. And then you've got David Tillman, 2 cases.
And Judge, Kevin Train, he's be coming up. This is one that me and Mr. I'm looking to talk about. They need to get him evaluated. And actually, one of the bailiffs let me know they've had an issue with him this morning. So
Let's go ahead and also reset Mr. Tran. We'll have an evaluation done on him if y'all wanted to get that order that we have for that to be done. Thinking about something else. All right, sir, are you David Tillman?
Yes, ma'am.
And All right, so it looks like there is, we've got cause number 22-40540 and 24-0536. And will your client waive the formal reading of the motion and the indictment?
Yes, ma'am.
Okay. Just a second to get there. Okay, Mr. Tillman, in cause number 240536, are we going on count one only?
Yeah, sure.
Yes, sir.
God bless you. The state has elected to proceed on count one only. It alleges you committed the first-degree felony offense of aggravated sexual assault of a child from August 15th of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yeah.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Also, in this case, do you understand that you will be required to register as a sex offender? It looks like you've signed that paperwork, and have you gone over that with Mr. Lewis as well?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tillman is not competent?
No, Judge.
All right, Mr. Tillman, in cause number 240536, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated sexual assault of a child. Sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Okay, and then,
And it's a little confusing, Your Honor. The motion does not contain that the offense he just pled guilty to, because the dates, the new offense predates him being
Gotcha.
put on probation, so it's not
Okay.
part of the revocation.
gotcha, thank you. All right, and then in cause number 22-40540, I have a motion to revoke your community supervision. Shows that you were placed on probation May 1st of 2023 for the offense of unlawful possession of a firearm by a felon, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am, that's true.
And it alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 2 alleges that you failed to provide verification of entering and successfully completing the MRT, the Moral Recognition Therapy Program. Is that true or not true?
That's true.
And then count 3 alleges that you are behind in your court-assessed fees. And is that true or not true?
That's true.
Did you enter your pleas of true to each of those counts freely and voluntarily?
Yes, ma'am.
And did you plead true because those counts are actually true?
Yeah, true.
I also have some documents here on the computer in that case that have your signature on them that the state's marked as exhibit number 1. Did you also go over these with Mr. Lewis?
Yes, ma'am.
And do you fully understand them as well?
Yes.
And do you understand, again, if I follow the agreement in this case, you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. All right, Mr. Tillman, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 2 cases will run concurrently, which means together at the same time. I'm handing you now, in each of your cases, the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. We already went over that when I put you on that probation. I just want to make sure you understand, based on the judgments in both of these cases, you are ineligible under Texas law to possess a firearm or ammunition. If you have any questions about that, make sure you read that document and talk to Mr. Lewis.
Yes, ma'am.
All right, good luck to you, sir. You can go back with the bailiff.
I have one question.
Yes, sir.
Does the time I get credit also include the time I was in Oklahoma?
So the time that you will get credit on is any time that you were either in our custody or that we had a hold on you. So if we had a hold on you from Jefferson County and you were in some other place being held, then yes, you would get that. If we did not have a hold on you, then you would not.
All right.
Okay?
Thank you.
Yes, sir. Jacqueline Young, Mr. Lewis.
And Judge, we do have an issue with this one on the plea. I was going to address once he came out.
Okay. Good morning. Are you Jacqueline Young? And
Judge,
Mr. Lewis?
Judge, we had an agreement on this matter. Of course, it's an MTRP and a new law violation. The plea was for 5 years on both cases to run concurrently. After looking at it, when we did the plea back, we realized that it was a significant difference in the credit that he has on the MTRP and on the new case. I was going to ask, after seeing that and kind of talking to him about that a little bit, if I could get possibly 2 weeks so I could talk with him and as well as his mother. She's been pretty active in contacting. She's not here this morning, but.
Yeah, I mean, I'll do that. You'll have to redo the paperwork. I'll have to delete all that paperwork.
I'll go ahead and redo it.
And obviously, the fact that I don't know that, I mean, y'all can renegotiate, but I probably would not be inclined just because he doesn't have credit on a
Right.
new case that he's on to do that. But if you'll just explain that.
Right, I want him to totally understand what he'd be getting for
Sure.
parole-wise, eligibility and all that.
Okay.
And it's not going to be a reduction in the offer or anything, Your Honor. He wants time to make sure
Sure.
he understands what he's
Okay,
saying.
we'll do a 2-week reset.
Okay, thank you.
Thank you. Mr. Parker, you've got Jennifer Bowles. Let's see, I need to send that back to you and delete all those, I guess? Not on the other one, okay. Good morning, are you Jennifer Bowles? Give me just a second here. And will Ms. Bowles waive the formal reading of the motion?
Oh, yeah.
Ms. Bowles, in cause number 18-29814, I have a motion to revoke your unadjudicated probation. shows that you were placed on probation January 28th of 2019 for the offense of fraudulent use or possession of identifying information. That was a third-degree felony, and that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you provided a urine sample October 24th of 2023 that tested, and October 25th, that tested positive for methamphetamines, amphetamines, and ecstasy. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample January 25th of 2024 that tested positive for methamphetamines and amphetamines. And is that true or not true?
True.
Count 3 alleges that you failed to provide verification of attending the DROP program January 2nd, January 17th, January 20th, January 29th, and February 5th of 2024. Is that true or not true? Count 4 alleges that you're behind in your court-assessed fees as of January 25th of 2024 in the amount of $4,972.61. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
Objection.
It's admitted. Is there any evidence that Ms. Bowles is not competent?
Negative.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of fraudulent use or possession of identifying information. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. That will also run concurrently or at the same time with the Orange County case that you're currently serving any time on. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I've provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Parker. Good luck to you, ma'am. Thank you for being here, sir. Theodore Briscoe, 2 cases. There's no agreement on this.
No, I'll leave it there, I'll explain.
Okay. Good morning, sir.
Good morning.
Are you Theodore Briscoe?
Yes, ma'am.
And Mr. Briscoe, in cause number 234535 is on probation for evading arrest or detention with the use of a vehicle. And in 236055 on probation for possession of a controlled substance.
Yes.
Motions to revoke those probation have been filed. Mr. Parker, announcements.
Your Honor, just for the record, I went to see him at the jail and they told me he wasn't at the jail.
Oh,
So I didn't get to visit him, and
Okay.
he was here. I got to visit him this morning. I told him that the court would probably give us more time to go over it if we wanted to, but I think we just need to go through the motion.
Without an agreement.
Without an agreement, I think he understands that.
Also, there's a drug charge that hasn't been filed yet, just for the court's knowledge.
Okay. And so, Mr. Briscoe, we can go through those motions today, get pleas are true or not true, or I can reset your case just a few weeks if you need more time to visit with Mr. Parker since he, okay. So let me get that pulled up.
And they're the same violations on both cases, Judge.
Can I get 36055 printed, please? Oh, no, that's okay. I gotta make marks on it. Thank you. It's just hard to do when I do them both on the computer. All right, in each of these cases that we've talked about, Mr. Briscoe, again, I have motion to revoke your unadjudicated probation. In 20-34535, the motion shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? And in cause number 20-36055, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 15th of 2021 for the third-degree felony offense of possession of a controlled substance, and that was also a 5-year deferred probation. Is that also correct? Each of these motions allege that you violated your probation. Count 1 in each of the motions alleges that you committed the new offense of possession of a controlled substance January 5th of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 in each case alleges that you committed the offense of assault causing bodily injury to a family member January 5th of 2025. And is that true or not true?
Not true.
Count 3 alleges that you committed the new offense of interference with an emergency request for assistance January 5th of 2025. And is that true or not true?
Not true.
Count 4 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
And count 6 in each case alleges that you were behind in your court assessed fees. And is that true or not true? Did you enter your pleas of true in each case to counts 1, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find in each of your cases that you entered your pleas of true to counts 1, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case for sentencing. Mr. Nichols, does the state anticipate bringing witnesses for either of those cases?
Yes, Your Honor, I'll have to call witnesses to prove up the 2 that
Sure.
pled not true to.
Do you anticipate that taking longer than an hour or so?
I do not, Your Honor.
Okay, we'll just set it maybe at 11 on a regular docket day. I will ask probation to do an updated pre-sentence report. Mr. Briscoe, obviously anything that you think is important for me to know, make sure and get that information to Mr. Parker. He will present it to me on your behalf when we come back.
Yes, ma'am.
All right, we'll see you back at sentence. Yes, it's unagreed. God bless you.
Come over here.
No, that's what Jake.
David James, Mr. Parker.
See if I'm right. Just no, not this one. See if I'm right.
Thanks for being patient this morning, Mr. Parker.
Mr. Millhouse was laughing at me, Judge.
Why? Because I put you last?
Yeah. 'cause
It wasn't really intentional. It
I
just
was
kind of
here
worked
first
out
and-
that way.
I was here first and he laughed at me.
You are always first, and I typically try to take notice of that. It just
Did you
didn't.
notice that the Jester was the best George we've ever had?
Good morning, sir. Are you David Wayne James?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment and the motion?
Yes, Your Honor.
Mr. James, in cause number 250522, you're charged with the third-degree felony offense of collision involving serious bodily injury from February 16th of 2025. And how do you plead to that charge?
I plead no contest.
You either did it or you didn't do it.
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they've charged you with?
Yes.
All right. Then I have here on the computer in that case some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, sir.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Right, yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. And that, is that your understanding of your agreement?
Yes.
Okay.
The other case is, if you can't read my writing, it's extended probation and safety relapse.
Okay.
You can read it.
I guess the length of time in the probation is something that, obviously, the length of time on your probation, because it's even written on here, on this one, I can give you any amount of time in probation, so I don't have to follow that 5-year. If I give you the probation and sentence you to probation, the 10-year term in prison, probate it for any number of years, you understand that you'll be waiving your right to appeal. So the thing is, until I see an updated pre-sentence report and really see what's been going on, just on the face of this, it makes me have a little bit of pause because you're already on a felony probation and there's a new felony offense. And so I'm not sure that the length of time of only 5 years is something that I'm willing to go along with, but I'll take a look at it when we come back for sentencing. Do you understand?
Yes.
You know, I've explained that to him, and I've explained to him that some courts don't even consider that. They automatically do it 10. But if you do everything you're supposed to do, the judge can always let you off probation early.
Correct. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1 in that case?
No objection.
It's admitted. Is there any evidence that Mr. James is not competent?
No, Your Honor.
All right, sir, in 250522, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to reset your case so that the probation department can do a pre-sentence report, give me an update, obviously, on the probation case, as well as more information on this offense, and then we'll come back later for sentencing. Now, in cause number 1523545, I have a second amended motion to revoke your unadjudicated probation. Shows that you were placed on probation November 13th of 2017 for the offense of burglary of a habitation, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of possession of a controlled substance, February 3rd of 2025 in Jefferson County, Texas. And is that true or not true? Count 2 alleges that you committed the offense of possession of drug paraphernalia on February 3rd of 2025. And is that true or not true? Count 3 alleges that you failed to avoid persons or places of disreputable or harmful character, specifically by associating with past associates who are actively using illegal substances. Is that true or not true?
True.
Count 4 alleges that you provided a urine sample September 23rd of 2024 that tested positive for cocaine. Is that true or not true? Count 5 alleges that you provided a urine sample January 27th of 2025 that tested positive for methamphetamine. Is that true or not true? Count 6 alleges that you failed, nope, we're going to keep going. I want to know all of this if I'm going to consider leaving them on probation. Thank you, though. Count 6 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you provided a urine sample on February 3rd of 2025 that tested positive for alcohol. Is that true or not true? Count 7 alleges that you're behind in your court-assessed fees as of February 3rd, 2025, in the amount of $1,689. Is that true or not true?
That's true.
Count 8 alleges that that doesn't really give me.
Yeah.
All right, I'm going to skip 8. Count 9 alleges that you failed to report to the probation department as directed on February 7th of 2025. And is that true or not true? Count 10 alleges that you were at a location other than your residence at approximately 11:51 p.m. February 16th of 2025. Is that true or not true?
That's true.
Count 11 alleges that you failed to submit to the alcohol or drug screening as directed February 11th, February 14th, and February 19th of 2025. Is that true or not true?
That's true.
Count 12 alleges that you committed that new offense of collision involving serious bodily injury February 16th of 2025. And is that true or not true? Did you enter your pleas of true to all of the counts except, let's see, 8, which is the one that I left out, freely and voluntarily?
Yes.
And did you plead true to all of those counts because they're actually true?
Yes.
I have here on the computer some documents that have your signature on them in this case as well. Again, did you go over these with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
You understand if I follow the agreement that you've made with the district attorney that you would be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement in this case would be for me to continue your probation, extend it for 2 years, and order you to the Safe B Relapse Program. Is that your understanding?
Yes.
State tenders number 1.
No objection.
It's admitted. All right, so I'm going to find that you entered your pleas of true to counts 1 through 12 minus 8 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I'm going to reset your case, again, to get an updated report about this case as well as a report about the other case, and we'll come back at a later date for sentencing. All right, you can go back with the bailiff.
Thank you.
Yes, sir.
I apologize. Yes, Chief.
Well, he'll still be going. So. I've had several of them like lately that have some of our administrative stuff. I'm like, why don't you just do your probation, get over with, and get off of it? You know, I mean,
Darren Walker, Mr. Parker, 250256. You good over there?
hey, they've been pressure washing that thing. It's hilarious because they don't know what they're doing. They did what Friday or something right there. They're gonna be back, you know.
Good morning. Are you Darren Walker?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
You will, Your Honor.
Let's see. Are we going on count 1 only? The state jail felony? Not all the
It's a
others?
state jail felony, yes.
Right, yeah, but there's all
Yes,
these
we're going-
priors.
yes.
Yeah,
Count 1 would be the previous invading.
okay. Now hold on a second. Let me get this pulled up right. Mr. Walker, the state is elected to proceed on count one only. It alleges that you committed the offense of evading arrest or detention with previous convictions from October 19th of 2024. It alleges you were previously convicted of evading arrest or detention October 21st of 2011. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Walker is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest or detention with previous convictions, sentence you in accordance with your agreement to a term of 12 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Mr. Parker.
Thank you, Mr. Parker.
See what goes on with it. I do believe it's inappropriate, but I wanted him to have the opportunity to address that. He has court in this court tomorrow. So he's gonna be here tomorrow for that case. I do have a letter from June 9th from his probation officer in 25th District.
Mr. Nahiki, this has been going on for 4 years.
I understand. At the time, he
Let your lawyer talk,
he
don't
was
interrupt.
an addict. He
I know, but he-
understands he had issues. He's been clean and sober
Okay, I get it, yeah.
for 3 years.
Okay. Listen, I'm not adjourning it. Request denied.
No, I'm not adjourning.
Good, then don't say anything. I'm going to sentence you on this violation right now.
Okay.
Okay? You should have been here. You didn't show up. Judge McNally doesn't like that.
I understand.
Maybe there's more judges somewhere out there that are a little bit more tolerant of it. Good for them.
I understand that. Your
Okay, you're not going to play with courts and you're not going to ignore courts. I gave you an opportunity back in August of 21 saying, go test. And I set the sentence. And then what, did he even go testing as well? What's your name?
Elizabeth Voss, probation. No, Your Honor, I believe I marked the file. He did not test, but no, he did not test as part of that order on August 2nd of 2020.
So I'm sorry, I'm not going to adjourn it. I'll listen to whatever anybody has to say.
So the biggest reason I'm asking for that adjournment is he's about to join the union.
I don't care if he's going to join the United States government. I'm not going to adjourn this case. Period. Period.
Your Honor.
No. How many times I got to say no?
Yes, understood, Your Honor.
What would you like to say before I sentence him?
I would ask that the court allow me to read the letter from the probation officer.
Sure, absolutely. Or I'll read it, whatever you want.
It says, Mr. Biesinger is currently under supervision at 25th District Court for OWI impaired offense. He has consistently appeared for court reviews and probation appointments since November 2023. Throughout his probation term, he has attended AA, secured a sponsor, recently entered outpatient substance abuse counseling at the Guidance Center with Joshua McAllister. Mr. Biesinger will be discharged from probation July 24, 2025, as the court will be losing jurisdiction at that time. Please feel free to contact me with any questions or.
He's not in sobriety court, right?
No, I believe it's just a normal probation. His officer is GN Mendenhall.
Is that for the aggravated assault, or is that for the operating while impaired?
Operating while impaired. And he's been on that probation. He's doing therapy 3 times a month. He works 2 full-time jobs. He's about to get into the union at Caden Plating Factory. He's been sober for 3 years. Obviously, at the time, he didn't have everything going for him. I think he does now, and I think really that's the most important thing. Obviously, the goal of his original probation was to get him to the point he's at right now.
Well, the goal was also to make sure
I understand.
not commit other crimes, and went out and got an impaired and he got an aggravated assault.
Right, I understand that. But at the same time, I do think he's made tremendous strides, and honestly, I think this is somebody that should be given the opportunity to avoid a jail through maybe court work program days. If he doesn't get those done, well, then that falls on him. But he's at a good point in his life. He could drug test today, he could drug test tomorrow. It's not going to be possible. He's clean, he's sober, he's doing the right things. I just don't think it would do him any benefit to be incarcerated. Obviously, the court has the ability to do that, but we're just asking for some grace here. I mean, I think you know Mr. Biesinger. I think the person you knew back then isn't the same person, and I think that does matter.
What did he do, if anything, on this? Can you tell me?
I would love to be able to give him a positive report, but he did not attend any of his court work program days. Just in my last communication with him I won't say complying with his probation, but when he was actually reporting, he still owed all his fines and costs. I scheduled him for the court work program. He did not show for any days on the court work program. I will say he did show me proof that he was employed in June of 2021. As far as treatment's concerned, again, no verification that he completed his treatment at the time he was at the Guidance Center as well. With his chemical testing as the show cause, he didn't go as part of bond, he didn't go as part of probation. And that's in reference to your case, Your Honor. Of course, we have other issues that would contain on Judge Heston's case, but.
He's got a case in front of her too?
He had a case in front of her at the time, that ended in 957, yes, for a substance possession use case.
I can call those with you here. That ended on 957.
No, the case number ends in 957, Your Honor. I'm not sure if you have it on your screen.
Oh, I see. Go to number 13. Oh, has he been sentenced on that yet?
Yes, Your Honor, he was placed on probation.
No, I know, but has he gone back on some kind of a violation since then?
He did not appear. I believe I'd have to check his court date on that one.
Okay. Anything else that you want to say, Ms. Wilds?
Nothing else as far as, Your Honor, as you know, it's over 2 years old. I'll give him credit for being sober, but he's been sober for 3 years, but he didn't have the wherewithal to come in and speak to us in 3 years. Being on probation for 2 years for an OWBI over in 25th. As far as court work program is concerned, again, he didn't do any days. I understand use, I understand non-compliance, but at this point in time, he's not a candidate for anything associated with probation. He's already proven that he can't show in court, he can't show in court work program, probation. I do recommend jail at this point in time. It's been far too long, and he's had a lot of opportunities to rectify this in the proper way.
Anything you want to say, Mr. Biesinger?
Your Honor,
2019, 2020, 2021, all those years, I was a full-blown heroin addict, okay? I was on heroin for about 8 years. Back in 2023, I had my daughter, Liliana. I got sober. I went to Sacred Heart. I got sober. I worked cement in the morning. I've been working at this factory from 3 to 11 every night. I've been doing wonderful. This is the best I've ever done in my life right now. I completely understand that I should have came in here, took care of this, got back on probation, all those things. I brought it up to Ms. Mendenhall before. Everybody has always told me, take care of it in the future, which that part, I completely understand. Now I'm here.
Take care of it in the future?
Yeah, that's what everybody's always
Hang
said.
on, whoa. A probation officer in another court told you, knowing that we had a warrant out for your arrest, to quote, take care of it in the, hey, let me finish. I just want to know who I'm calling over there. I want to know what judge to call. I'm going to figure out who the chief judge is. I want to make sure. A probation officer, Ms. Mendenhall, told you, knowing that you had a warrant out of this court since 21 to quotes, take care of it in the future, period, end quotes. That's what you're telling me.
Yeah.
Okay. Okay, I just want to be sure before I start making phone calls.
And I see Judge Clifton also every month. I see him, I see Miss Mendenhall.
How do you see Judge Clifton every month?
Because I see Miss Mendenhall and then I go in the courtroom and talk to him about how's my month going and things like that.
Sobriety court?
Yeah.
You're doing drug court?
No, not drug court, but I go see Miss Mendenhall every month, and then right after I see her, I go into the courtroom and talk to Judge Clifton also. He knows about me. He's very proud of me of how much better I'm doing. And this is the best I've ever done right now. I mean, I have 2 jobs. I'm taking care of my daughter every day. I have a car. I'm about
Hang
to
on a
join the union.
second. Hang on. Are you going into, I just want to be clear about this. Are you going in and sitting down with other sobriety court or drug court participants and talking to the judge? Or are you just going in and having a chat with them because it happens to coincide with the date that you're going in to see your probation officer and you just want to go and say hi and see what?
No, I'm scheduled once a month to go see the probation officer and then see the judge. So I go see Miss Mendenhall, talk to her for about a half hour, and then I wait for, and I go into the courtroom, and then I talk to Clifton for about a half hour. Not a half hour, about 20 minutes. But I see.
Does anybody else do that?
I don't know.
I mean, I'm just saying, when you're having this conversation, are there other participants in there?
No, it's just me. It's just me that I know that does this.
I can tell you, Ms. Mendenhall, I don't believe is the sobriety court officer over there. I believe, probation officer by the name of Simone Kissinger, I think is her last name. I don't believe Ms. Mendenhall does sobriety court or drug court over there. I could be wrong as far as I'm not employed there, but to the best of my knowledge, she's just traditional probation.
Your Honor, I completely understand about all these violations of probation, but I just want you to realize, like, I was a heroin addict then. Like a few years ago, I was a full-blown heroin addict crackhead living in the streets of Detroit. Like that, I didn't have no responsibilities in my head. I didn't think about coming to do a work program, none of that. I didn't answer to nobody then. Now, going on 3 years of sobriety, I really am a completely different person. I really am.
You went out and committed 2 crimes since you were in front of me. One's aggravated assault, which means you caused a serious injury to someone.
Right, that's when I was.
Let me finish.
Using.
And another one was impaired. Now, it's good that nobody was killed in an impaired action in the impaired charge. And it's good that you stopped without causing somebody grave injury or serious aggravated injury. I mean, you caused an aggravated injury, which requires somebody either to have a serious injury or at least go get medical treatment. And both of those happened after here.
I understand.
And I'm not buying this that some probation officer told you to take care of that in the future. If they did that, I'd fire them. I would fire them. Who do you think you are, Ms. Probation Officer or Mr. Probation Officer, telling somebody else to take care of a warrant that's out for their arrest sometime in the future when they feel like it, essentially?
I am a completely different person, Your Honor.
But here's the problem. You might be. But I really don't have any proof of that. I mean, I have a letter that somebody wrote me that told you to go there in the future.
Yeah.
You can't do this.
Your Honor, I could draw for you right now, anything.
Anything else you want to say? Because once I'm done, I'm going to make my ruling and I don't want to hear any lip. You got it? Do you understand what I just said?
Yeah.
Okay, go ahead, finish.
I would just ask again for some sort of requirement in lieu of jail. I know that, it's not a recommendation of probation, but at the same time, I do think, given the fact he's being monitored by another court, given the fact that he's gonna be in this court tomorrow, that he's neither a flight risk, he's not a danger to the public at this point. I think he should be given an opportunity to avoid that jail time through a court work program that was originally ordered. You can order 5 days. 5 days he doesn't do them, he goes to jail. You can say, hey, if you don't do these days, even you miss one, you're going to jail. Set the amount of jail. I'm just asking for some.
Let me see the screening again, Lee.
To give us a chance to avoid that and keep on the right track like we are right now.
Your pet, Does he have any credit coming on this, Beth, to your knowledge?
Not to my knowledge. Again, no days completed on the court work program. I will definitely look and see on the ROA if there was any credit at the time of his arrest or detainment. It looks like you gave him credit 1 day for any detainment of police. But again, the 5 days that he was to do in lieu of serving jail, he did not complete.
Anything else? You've said everything, but I just want to make sure I've let everybody speak.
Just that I'm very proud of myself right now at the end of the day. You know, like if I wouldn't have wanted to deal with this, Your Honor, I wouldn't have came this morning. You know, I got up early, 7 o'clock in the morning, sharp, got here. I joined the union next week.
You were in custody June 2nd.
June 2nd.
Right? Weren't you
I just did 2 days when they pulled me over 2 weekends ago
So
over
you
the
were
case in 2019. So I did 2 nights. Saturday night, Sunday night, bonded out for 500, Monday, and made it to work by 3. So at least I got out and got my car back.
Probation's revoked. You're to pay costs of $1,000 and serve 90 days, credit 1 for 89. If you pay costs of $1,000, I'll suspend 59 of the 89. You only have to serve 30. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. So you're going to serve 30 days. You've got a bond of $250. I don't know whose name it's in. I gotta go to
jail.
What did you think? Have a seat. I'm not gonna argue with you. You understand what I'm saying to you, son? Should have been 90. Good luck. Have a seat. People against Walker, Christopher Raymond Walker, 25W727443. Your name?
Christopher Raymond Walker. Let me do it, brother.
All right, Mr. Walker.
Good. I will need to give him back to there yet.
Your name, sir?
Christopher Raymond Walker.
All right, so I am bringing him, entered a not guilty plea. He has one prior violation on April 14th, which concerns me because he was placed on probation in February. How's he going to proceed on this?
Your Honor, ultimately, it is going to be a plea. Like last time, we are asking for an adjournment. The reason being that Mr. Walker is seeing a psychiatrist in 2 days to get a Vivitrol shot, which is going to help him with his alcohol cravings. And we really want to make sure he gets that prior to the court imposing any sort of sentence. We're happy to take a plea today, set it for a sentencing.
Well, if you want to take a plea, you can take a plea. I doubt I'm going to adjourn it, okay? but, so that's it, or else we can have a hearing.
I would say that we take a plea.
All right, sir, if you plead guilty, this would be a second violation. You could get 10 days. Do you understand that?
Yes, sir.
And did you sign, read it, understand the advice of rights?
Yes.
Excuse me, if you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, to the charge that you failed to refrain from consuming alcohol, testing positive May 19th of 25, how do you plead?
Am I able to speak for myself for a second?
I just need to know how you plead first.
I plead guilty.
Did you consume alcohol within the 3 days preceding that test?
I have a problem.
Anybody force you to plead guilty?
No.
Call in Beth. I'll accept the plea. I find it to be an accurate plea, made voluntarily and understandingly. So he's going to get Vivitrol in a couple of days?
I'm also going to IOP 3 days a week now. I did it myself. So I stopped, I was going to group once a week. I started going to IOP 3 times a week for 3 hours every single week because I know I have a problem, and it's not just, I know I have a domestic violence charge, but before that, I'm not a violent person. I've been going to my anger management stuff and doing everything that I'm supposed to do. I have a problem, and my family knows about it now. They're talking to me. I didn't talk to my family before. I'm finally opening up about it. I'm figuring out who I am. It's an issue. And I talked to my therapist about it, and he said, yeah, you have a problem. We need to get you somewhere.
Okay.
So I'm trying to figure out how to deal with it. It's just very difficult. It's just probation got in the way with all this other stuff, and I didn't know how to take care of it. And now that I'm kind of figuring out how to voice myself, it's been a lot easier, I guess you could say, to figure it out, but it still is an issue, and I'm just trying to get help, and that's what I'm doing. I'm taking steps towards becoming a better man and taking care of myself as well as my kids as well, but it's a long road. It's gonna take me time.
All right. You get a hold of Beth.
She was down here, Judge. I told her. She's on her way.
All right. Did you do the, have you started the domestic violence program?
Like the anger management thing? Yeah, yes.
How far along are you in that?
I think I only have 1 day left or 2 days left.
All right.
Yeah, I've already started that. I've been doing that. The lady's name is Katie. She's an amazing person. I love going to it and talking to people because everybody in there has different stories. So it's nice to just talk to people and see how everybody else has different stories about, their domestic violence, what they did. And I'm like, I'm not that bad. I really am. I'm not an angry person. It was just alcohol that did it to me. Because the night that I got the domestic violence charge was because I was drunk.
Well, I dispute that. Beth,
Elizabeth Prosecution.
in other words, that's not a justification.
No, that's not. Not an excuse, but it can be a factor.
All right. What do you have to say, Ms. Wilds?
Yeah, as far as his use, I wish I could have positive things about Mr. Walker in regards to his use. I just got lab results from his next chemical test. I violated him for the May test. He was positive, confirmed positive ETG and ETS on June 4th as well, Your Honor. I think Mr. Walker has a much bigger problem than he's even willing to acknowledge. He might say he has a problem with alcohol, but the fact that there's continued use, even on surprise tests for him, it's a huge concern of mine. To his credit, he did start IOP. He is attending IOP with the Guidance Center. He shows up for his visits. He is polite. He again goes through all the motions, but I think this issue with alcohol is a much bigger brick wall than I think even he realizes at this point in time, Your Honor. And it's very concerning that his testing essentially is all positive for alcohol.
I do think he recognizes that, and that's why he's seeing psychiatrists to get the physical shot.
Okay.
I'm sure. And that's in 2 days, Your Honor, so if jail's a possibility, I really would be asking for an adjournment until 6/22. I'll be here. Just allow him to get that, and then if the court wants to sentence him to jail, sentence him to jail on that day. But I do think that's the most important thing.
Well, we're gonna make sure he's not gonna drink again. 2 days court work program, pay $35 a day for that. He's to test,
Weekly,
let me finish.
sorry.
He's to test weekly until October 1st, bi-weekly until February 1st, then monthly. He's to be on a SoberLink device by the end of the day until September the 30th. So you owe $75 plus 70 for the court work program. You're doing 2 days. You're gonna test weekly until October 1, bi-weekly until February 1 if you're clean, and then monthly. One more time, you're going to jail. Do you understand me?
Yes, sir.
Do you have the money to pay this? 145.
Not today.
Pay by June 27th. Can you do that?
Yes, sir.
You have to get the SoberLink device by the end of the day. They'll explain it.
Okay.
All right, good luck to you. I'm gonna go on to these poor people that have been waiting here all morning, Mr. McGee, and then I'll come back. Michael Christopher Mackey, where's the officer at? I need him. 25B148256.
Who's that, Du Bois?
Yeah.
Oh, he went to, he's got an exam in front of Judge Hudson.
Okay, your name?
Michael Mackey.
All right, so he wrote here, no injuries, minor damage to other parties' vehicles. So I'll take your plea. You're gonna plead to impeding?
Yes.
Responsible or not responsible today?
Responsible.
Please accept the original charge dismissed. 195 is your total,
I
okay?
have a,
How long do you need? June 27th, can you pay by?
I can do the 17th, but can I do monthly? Is that?
Where do you work at?
I work at AP.
How much do you make? Well, how much, just tell me real quick. You can pay, how much by the 17th?
I can pay at least 100.
All right. Pay 100 by June 17th and then the balance by July 17th?
Yes.
All right, I'll let you do that. If you need more time, you come talk to me, okay?
All right, thank you so much.
You're welcome. Carolina Irene Rose, 25B148365. Where's Ms. Rose? I just need clarification. Is he in the exam?
I don't know, I'll have to go see. He said he had an exam with Judge Hudson. I'll go in there and see.
Lisa, can you tell if Officer Dubois is in Judge Hesson's?
No, I don't have cameras on my screen.
Just call over to Carl. Tell him to send Officer Dubois here. 1 second behind there, okay? Have a seat right behind you. Miranda Renee. Yeah, Miranda Renee Shelton. 245B14836631. Your name?
Miranda.
All right, so he's clarified minor damage to the other parties. You're going to plead impeding?
Yes.
Responsible or not responsible?
Responsible.
Please accept it, 195. Yeah, I mean, so why is he leaving?
I don't know.
195 is your total, okay? Thank you, good luck. Okay, Ladale Brookins. 25B14862A and B. All right. Your name?
Darrell Leslie Wilson.
No. I'm not on that case right now, sir. Just give me a second. You're going to plead to impeding, Mr. Brookins?
Yes.
And then they're going to dismiss the no proof?
Yeah.
To the charge impeding traffic, responsible and not responsible. Please accept it. The no proof is dismissed. 195 is your total. Wait 1 second. Sure. No problem. I'll just give you till Friday. Fair enough?
All right, thank you.
13th. Have a good day. Okay,
Which one does he need to,
these are all set.
which one of those are due boys need to get fixed?
Irene Rose, 258-148-365. Your name?
Delina Carr.
I need you to be a little bit more clear here. Rose Carr. Minor injury reported by the other driver?
That's what the UT10 show, the minor injury. A complaint of back pain, to be specific.
I just can't do it. I feel bad. I'd like to help you. I really would, but I just can't do it. I'm sorry. I can give her 1 point if you want to do a 5 over. I mean,
If she's willing to accept that offer, Your
do you
Honor.
want to do that or do you want to come back for a hearing? Is this your mother? I just can't do it. If I do that, I just can't do it. I just don't feel comfortable with it. I'd like to, but I don't feel comfortable.
May I give him like a little input from before?
Yeah, you can have some input.
He like got out of the car and started like screaming at me and like he braked and there was nothing really in front of him and he was walking completely fine and then once the ambulance got there, he like held his back and like laid there like he couldn't walk.
Yeah, but he was actually transported. I cannot do this. I mean, if you want to have a hearing, I'll be glad to give you a hearing. I cannot do it. They had an ambulance take him to the hospital. You know, I just don't feel comfortable. I've thought about this for decades. I mean, I've been doing this the same way. I mean, if somebody runs through my car or runs through a light and sends my child or my wife or me to the hospital, I don't think they should get impeded. I'm just sorry. That's the way I look at things. So if you want to write it up as 5 over, I'll do it. Be glad to, or else you can have a hearing. It's up to you. Do you want to think about it? Go talk to your mom?
Yes, please.
Yeah, you do that. You seem like a real nice kid. This is nothing personal, believe me. Give that to the officer, please. All right. Ricky Lee Worthen, 21W828-077. Where's Ricky Lee Worthen?
He's in the jail, Judge.
What's that?
He's in the jail labeled SMT hearing.
Oh, Mr. Worthen, your name?
Ricky Lee Worthen.
All right, I said adjourn hearing May 14th. I said defendant will talk to girlfriend about her coming up and paying the restitution, then I'll waive balance and fines and costs, and I adjourned it. How much does he owe? He paid the restitution? You paid the restitution, it looks like, right?
Yes, he did, Judge.
I did, Your Honor.
Let me get Jessica in here real quick. Well, that's good. That's what I wanted the most, is the victim to get reimbursed. Just give me 1 second.
Yes, Your Honor.
So all I did was order you to not to enter 23300 West or any other Home Depot and to pay restitution and fines. Didn't do anything else. Your name?
Just hold on, I'll have a probation, Your Honor.
So you paid the restitution.
That's correct, yes.
I'm gonna dismiss. I'll tell you what. Are you getting your life in order?
I am, Your Honor.
I want to go ahead and dismiss the show cause. Defendant paid restitution, so I want you to do a discharge.
Discharge.
Defendant paid restitution, fines, costs waived. Defendant discharged without improvement. Okay, but I will discharge you. You're all set. I wish you well. Do you have any other case with me, sir?
I do not.
All right, best of luck to you. Thank you.
Thank you, Judge.
Thank you, Your Honor.
Horn, Nicholas J. Horn, 25704-225.
Good morning, I'm Lincoln Gate, Advisory here on behalf of Mr. Horn, who is present to my right. State your name correct. Nicholas Horn.
All right, so he's got these 4 violations. He's got 1 prior technical. How's he going to proceed?
We are trying to see if the court would be willing to accept the plea to less than all of the violations. It seems like, based on those numbers, there were 2 uses, and the other ones, they were going down. So we're trying to see.
Well, they were quite a bit apart.
Yeah, the 4.7 was a high number, and then the 4.22.
Yeah, but that is not,
But those levels go down. I mean, they're gonna show
It should
up.
dissipate in 3 days if he hasn't drank.
This was for.
Oh, chemical testing. I mean, if he doesn't think he used more than twice, we'll have a hearing. That's fine, if that's what you guys want to do. What's she gonna do? What's she gonna do? Officer, what's she gonna do?
She's gonna request an informal hearing, Your Honor.
Okay? You guys back off for 1 second. I'm gonna get this poor lady out of here. Carolina Irene Rose, 25B148365. Okay, young lady, your name?
Delina Carr.
All right, so you're going to request a hearing, right?
Yes.
Lisa, we're gonna give her an informal hearing date real quick.
June 25th at 9 o'clock.
June 25th at 9 o'clock, okay?
Thank you.
So we'll set it then, all right? Best of luck.
My name is incorrect.
What is your name?
Delina is my first name, then Irene Rose is my middle name, and then Carr is my last name.
Delina, Dylina?
Yes.
Not a car.
Carr's my
I
last
see. So it's Delina Irene Carr.
No, Delina Irene Rose Carr.
Thank you.
Yo.
So, Lisa, we're taking out,
I'll fix it.
yeah, I kind of making a mess here. All right, go down the hall, June 25th. We'll see you back here at 9. Go down, get your notice. Good luck.
Thank you.
I'm gonna need Emily to see it.
Judge, what?
Nicholas Horn. Daryl Leslie Wilson.
Just wait.
20F233084, B and C. Your name?
Daryl Leslie Wilson.
Where's that other case where I'm supposed to do
Judge, I spoke with Miss Tulaz. She is in Judge Hessen's courtroom, but she said we can call her when you're ready.
Well, why don't you is she got an exam in there that's going on?
I'm not sure. She just emailed me and said she was in there in the Zoom waiting. Oh, she just logged in. She just logged in the Zoom.
All right. Who is the lawyer for Daryl Leslie Wilson?
Mr. Westmoreland.
I'm here, Judge.
This is 20F233084B. Your appearance?
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Mr. Wilson.
All right. Your name, sir?
Daryl Leslie Wilson.
All right. So failed to appear for a show cause. Are you on this? Speak patient with me, please. I don't know what show cause. He was supposed to be here for a show cause back in July of 24. Guys, come on. July of 24. He was in here in front of Judge Hessen, then he didn't show up, it looks like. So he was supposed to be here for sentencing July 22. I don't even know who the probation officer is on this. I am getting a little frustrated here today. I need somebody on this case, Daryl Wilson, and I need the show cause. I can guess at what it says, but I can't.
Your Honor, the last thing that happened with this case, I was incarcerated in Oak.
Don't say anything yet.
Yes, Your Honor.
Yeah, please. I'll stay right there, Mr. Westmoreland. I'll be right with you.
No problem.
Ashley Nicole Hansard, 25R513992.
Your Honor, 115-1530 on behalf of Ms. Hansard, who is to my right, stating the record.
All right, what is she doing?
We are asking for, Your Honor,
Where was she?
for the visit.
I mean, she hasn't done anything unless you can tell me she's been in the hospital or something for 6 weeks. I mean.
She's in the community service. She's been doing the 12-step meetings. She's.
All right, we'll have a hearing. We'll get Ms. Tessino in here on this one too. Have a seat, ma'am.
Thank you.
Judge, may I approach your court? I think this is the other judge. I figured he wasn't in here. The officer should have told me just without being in here. They're right there.
All right.
It's fine.
What do they need? What is it?
We need to look at review the report, Your Honor.
They want you for Mr. Unknown. You want to run strong for them?
What?
You need to run strong for Mr.
Well, yeah, because I need somebody to be ready to do the signing on record.
Is that for the felony arraignment?
Sorry, it's just a felony arraignment, not the signing on record.
Yeah, she's in the waiting room.
Okay. Do we have a lawyer for Sean Christopher Miller?
It's Corey.
Yes, Judge, I'm here.
We on Sean Christopher Miller, 25B 710187. Mr. Westmoreland, your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Miller.
Mr. Miller, your name, sir?
Sean.
All right, so he's charged. Let's take care of the felony first. Mr. Westmoreland, your appearance?
Attorney Corey Westmoreland, appearing on behalf of Mr. Miller.
All right, so he's got a charge of flee and elude fourth, drive while suspend, revoke denied first. How's he going to proceed?
Yes, Your Honor, at this time we are prepared to waive a formal reading. My client stands mute.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that? You have the right to a lawyer not only today, but at all subsequent court proceedings. Also, if you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that? You have the right to a probable cause conference within 14 days, and you have the right to a preliminary exam within 7 days thereafter. The probable cause conference, your lawyer will discuss this case with the prosecutor at the preliminary exam. People will have to show that the crime was committed and that you were the one who probably committed the crime. Do you understand that?
Yes, sir.
All right, June 24th at 9:30 will be your probable cause conference. Preliminary exam will be July the 1st at 11. You'll go down the hall momentarily. You'll get your notices. You'll fill out a petition for a court-appointed lawyer going forward. You will be in front of Judge Hessen on those days, okay? What do you have to say? Where's Mr. Westmoreland? What do you have to say?
In regards to bond, Your Honor, I would simply just ask for a personal bond on behalf of Mr. Miller. He did appear here today, assured me he would be appearing at all future court dates. He's looking to get back on track, and I don't believe he has anything pending or outstanding out of any other jurisdiction.
Detective, your name?
Good morning, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
Anything you want to say regarding bond?
Your Honor, I would just note that during this incident, Mr. Miller ran from no fewer than 3 different police departments that night. And also note that he called our department to report that he was fleeing from us. It's a very interesting case, but at any rate, I do not see he has any prior felony convictions. So I would leave it in the court's discretion.
Do you live on Kirkway?
No, sir.
Where do you live now?
I now live in Monroe, 2925 Second Avenue,
Hang on.
2925
Second Avenue in Monroe.
Avenue, Monroe, 48162.
All right. What do you mean he called the police saying he was fleeing?
Your Honor, he called our dispatcher knowing that Officer Walker was pursuing him and identified himself to our dispatcher and stated that he was fleeing because he was trying to make it to return his sister's car in Monroe because he didn't want to be arrested and have the car impounded. Officer Walker was able to pull us alongside the vehicle and make the identification by matching his Secretary of State photograph with the person he saw based on his reporting to dispatcher Schillingberg that he was fleeing.
All right. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. I'll give you a personal bond, somewhat reluctantly. No contact with prosecution witnesses except through your lawyer. Your court dates will be June 24th and July 1st. You have to appear in court as directed. You'll be in front of Judge Hessen. Go down the hall, get your notice, and you're all set. Any questions?
Judge, she has a show cause with me as well.
For is it show cause or violation of probation?
There's 3 cases total.
Sean Christopher Miller, 24B146046A. So that's all I have here besides the felony. Was there another one, Lisa?
There was a civil infraction, unpaid. I think it was a no insurance.
Oh, yeah. And 214-643-915. Okay, Mr. Westmoreland, your appearance again?
Attorney Corey Westmoreland appearing on behalf of Mr. Miller.
So I'm going to sentence him on this case, right?
I'm on probation.
All right, so this is what I wrote down when I revoked your status March 31, Mr. Westmoreland. I wrote 771 status revoked, conviction entered. Defendant says he's getting a job. Defendant to get back in treatment. And I wanted him to pay toward the restitution. It doesn't appear that he's done anything on that. So that's the problem.
Sir, I'm just getting back to work and getting bills paid, getting caught up. I don't believe I've gone past any deadlines for when I need to make a payment. When I need to at least pay my first payment. I haven't crossed any deadlines today.
I told you to pay $200 bi-weekly by beginning September 10 of 24. That's what I initially told you.
Oh, yes, sir, that was my original probation, and then I absconded from that.
And you didn't pay anything?
Yes, sir.
Well, what do you mean you haven't been?
Judge, I think you might be confused on this one. I have a note in here that you sentenced him April 28th with a new payment plan. So today is a new show cause.
You're right. Thank you. Thank you. All right, so this is a new show cause. Failure to attend his probation visit, May 27th. Failure to submit the testing as ordered, May 27th. Failure to provide proof of completing IOP with aftercare. That's it. Thank you. How's he going to proceed here?
Yes, Your Honor. After speaking with Mr. Miller regarding the violations, he is prepared to waive any sort of contested hearing and enter a guilty plea.
Is that right?
Yes, sir.
And the probation officer on this is?
Me, I didn't bring the file, but I think I'll be okay.
Okay, if you plead guilty here, again, you could get a substantial amount of time. Could get 90 days. Do you understand that?
Yes.
Did you sign the advice of rights and read and understand the rights? If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes, sir.
Okay, just keep your voice up nice and loud for me. To the charge that you failed to attend your scheduled probation visit, May 27th, how do you plead?
Guilty.
To the charge that you failed to submit the weekly testing as ordered on May 27th, how do you plead?
Guilty.
To the charge that you failed to provide proof of completing IOP with aftercare, how do you plead?
Guilty.
Did you fail to complete IOP with aftercare?
I haven't completed it yet.
Did you fail to appear for your probation visit and testing on May 27th?
I did.
Anybody in the world forced you to plead guilty?
No, sir.
Pleas are accepted, counts 1 through 3.
I did contact Ms. Casino as soon as I had realized that I had missed and talked to her about it. I have not missed any other ones. It was one day, we had one bad day at work where a bunch of people quit and we got caught up in everything. That was the day, 27th. That's why I missed both things on one day.
What do you want to say?
I do think Mr. Miller's making an honest effort in comparison to our last go around. He did contact me. I remember correctly, he went to on-site the next day and did do a makeup test. He has submitted to 2 tests since then, so he is doing the weekly. I spoke to Higuera today. I don't necessarily think him not being in treatment is necessarily his fault. He's a Monroe County resident, so it's been kind of tricky with the funding. So someone is supposed to be calling him today at Higuera at noon to get him into IOP.
Good. All right, well, that's kind of good news. I don't know if I want to sentence him today or not. I don't think I do. I think I want to set a sentencing date when Mr. Westmoreland's here in about 5 weeks, Lisa. And then you'll be able to start making your payments. You're going to start going to testing. You're going to make sure you get well underway on IOP. When do we have that, Lisa?
I don't have the schedule out that far, Judge. He's just I believe, arraignment attorney today.
I'm just the arraignment attorney, Your Honor. Mr. Miller was a walk-in today.
Well, why don't we just pick a date about 4 or 5 weeks out?
July 8th at 8:30.
Okay. July 8th at 8:30. I'm going to go ahead and I'm simply going to, on this other charge, the no insurance. Can you pay anything on this today?
That day, sir. But by Friday, I can.
How much can you pay Friday?
$100. Are you started on it?
You pay $100 by June 13th. 100 more by
I get paid every 2 weeks, sir.
June the 27th. You do that, I'll waive the balance. Okay?
Yes, sir, thank you.
On that, just on this case, okay?
I understand.
All right, you'll still have to pay the clearance fee too. So you could get out of this saving some money if you adhere to these payment plans, all right?
Yes, sir.
That's what I'll do. Go down the hall, get your notice, come in Friday with the $100, come back on the 27th with $100, pay your suspension for your clearance fee, and we'll go from there. Good luck.
Thank you, Judge.
Thank you. I don't even know where to go at this point. What else do I have here?
Mr. Wilson in custody.
Where is it? Yeah. We're gonna have to redo that. Was he with Mr.? He did. Send him back in. Daryl Wilson. People against Daryl Leslie Wilson. 20F233084.
Attorney Corey Westmoreland appearing on behalf of Mr. Wilson.
Where's Mr. Wilson at?
The Wayne County Jail.
Your name, sir?
Darrell Leslie Wilson.
All right, so defendant, let's just check here for 1 second. I just want to double check one thing. He didn't appear for this show cause that he was supposed to be here for. I'm sorry?
No, July 22nd, sir.
Just let me finish, will you?
Yes, sir.
On July 22nd of 24,
Right. I didn't know.
23. So it looks like he pled Mr. Westmoreland to all of these. Failure to report on January 19 of 23 and January 27. Failure to schedule and attend court work program days. Failure to pay fines and costs as ordered. Failure to submit to twice monthly chemical testing. Failure to provide verification of attending and completing outpatient, and failure to declare all warrants. So that's where we are with this. He's just awaiting sentencing. What would you like to say?
Yes, Your Honor. My client.
And on this?
That is her case, yes.
Yeah, I need her. Can you tell her? Go ahead.
Your Honor, I would like you to know that Mr. Wilson just served 30 days in Oakland County Jail. He now is in the Wayne County Jail where he's awaiting a tether. I would simply just be asking for credit for time served on his behalf. At the time, he was going through a very, very rough patch, as you can imagine. His father had just recently passed away. It had kind of sent him into a spiral, and he's finally picked himself out of it, and he's working hard to ensure that he never puts himself in this position again. Again, Your Honor, I'd simply just be asking for consideration for credit for time served, and hopefully you will never see Mr. Wilson again.
So you're still at it, huh? Still at it? How much does he owe, Lisa? Ms. Wild's your name?
Elizabeth Fleischer, Your Honor.
I'm checking, Judge.
You want to say anything, Mr. Wilson?
I had to keep muting him because of the background noise.
Oh, that's okay. You can unmute him now, right? You have to unmute, sir. There you go.
Your Honor, I thank you for giving me the opportunity to see you this morning, and I do have something to say. Your Honor, back when, like you said, last year my father had died, but at that time, sir, I was coming out of just sentencing a sentence at Oakland County Jail where I served 180 days. If you ought to have possession of some plea by mails, but I was just hoping to just clear all of this out. I have completed a residential treatment, an intensive IOP2 and an intensive IOP1, as well as aftercare. I'm now 1 year clean, Your Honor. I have not paid anything in restitution, Your Honor, but I am on my way to doing better. I'm getting myself together, Your Honor. This case right here, it's a disagreement between me and my wife. And so I'm waiting on the tether right now, but I'm hoping that we can resolve this so I can put this matter behind me, Your Honor. I'm doing much better. The only thing that I haven't been successful at is finding a job, and that's just because of just my circumstances. But I have been doing vocational training, so I'm working to get myself together so I can put myself in a better position for myself and my family, Your Honor.
I don't see any plea by mails in here.
I sent 2 of them. I was in jail. I was incarcerated from August 2023 to February 2024.
Here's one January the 11th of 24 we received on the 18th.
Yes, sir. Those are the ones I'm referring to, Your Honor.
And that's when I went ahead and sent. You're supposed to appear here in person in July of 24. Why didn't you do that?
Right, that's the one I was referring to when my father had passed away. Judge Brennan was courtesy, and she was generous enough to give me a personal bond that day. The funeral was on the 21st. And the court date was on the 22nd, you know, just dealing with family. And I mean, I didn't have transportation at the time, Your Honor, and having to depend on someone, and they were still consoling one another. I couldn't make it down here, Your Honor. I live in Grosse Pointe, Michigan. So it was just a significant problem for me to get there. Otherwise, I really would have made it, Your Honor. And I tried my best to make arrangements, and I have no excuse, to be honest. I just didn't come, you know, and I don't want to put myself in a position where I'm making excuses, because I'm not. You know, like I said, I take responsibility for my actions, and Judge Brennan was nice enough to give me a personal bond, and she understood my situation, but I tried everything I could. I just could not make it, sir. Public transportation would have got me as close as Southgate, and that would have been a hell of a walk to get to your judge, you know, to get there, but that was the only other option.
If I'd have told you I had $5,000 to give you if you got here, you would have gotten here. And listen, my condolences on your father, really. But you could have come in August, September. Don't give me this, okay, please?
Yes, sir.
I really don't want to hear it. I just don't.
Yes, sir.
I mean, you didn't show up. You got warrants all over the place here.
I have no warrants now. Everything is cleared up at this point right now, Your Honor. Everything is cleared up.
What do you have to say?
Yes, Your Honor, Elizabeth Wells, probation. Mr. Wilson didn't show for his instructional appointment, so I unfortunately don't have any type of update or any kind of credit that I can give Mr. Wilson. He absconded essentially right after his sentencing. I'm not seeing any days credit on the C case, but on the B case, it was written 18 days credit with 72 being deferred, Your Honor. I'm seeing on the ROA, the 20F 233084B, 18 days credit are listed in the jail days section.
Is that on B or C?
On the B case, Your Honor, on the ROA, on the cardboard. But other than that, I can't offer any kind of insight. It appears Mr. Wilson's in custody on a separate case. That's why he's present, you know, obviously in court today. And he's past his 2 years at this point.
I don't know what.
And I do want to also admit, Your Honor, that I have just completed 2 probations, one in Detroit and one in Oakland County. I have been on Oakland County probation for the past 3 years, Your Honor. That's what it's also make it complicated. I was on 3 probations at the same time. I completed in Oakland just this past Friday, where I just paid $8,000. I just paid $8,000. It was all I had, Your Honor, just to get off of Oakland County probation and completed the time allotted. And the Detroit probation, that one was dismissed as well, Your Honor. So it's not like I haven't been doing anything or reporting to anyone. It's just that, I mean, and I don't mean to disrespect your court or your probation officer at all, but it was literally just the farthest and the hardest to get to. And I had to at least put some sort of effort into completing at least one of them. So I did what I could with the two that I had down here that I could reach. And that's just me being honest, Your Honor. I really do apologize, probation officer. Like I said, it definitely wasn't anything personal, but it was just what I could do with what I had to do. Like I said, in the past, like 2 years, I haven't picked up any new cases. But this one right here is just a disagreement between me and my wife, and it ought to be resolved next Monday. I knew that you guys would consider picking me up, so I had tried to make arrangements to collect some sort of money, but I have nothing, Your Honor. I had to borrow like $2,000 from my mom last week, and I depleted my savings, so I don't have anything.
All right. You wouldn't have to spend time in jail if you didn't keep getting yourself in trouble. You blew the court off. I like giving people chances, but not when they blow the courts off. And you blew us off. Okay? I don't know why people do that. I don't understand it. They can give all the excuses they want. They were addicted. They didn't have a ride. They forgot. I mean, I could go on and on. I could go on for 20 minutes of excuses I've heard over the last decades. The fact is that it just isn't high on your priority list. And the fact is, you weren't going to show up unless you were picked up on something else either. So you got to make wiser decisions, Mr. Wilson. I'm sending you back to Judge Hessen on her case. On this case here, I'm revoking your probation. You're to pay costs of $625 and serve 90 days, credit 18 for 72. If you pay costs of $625, I'll suspend 37 of the 72, and you'll only have to serve 35. That is a gift. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You're going to Judge Hessen on that disorderly case. It sounds like you owe a lot more money on that. You'll have to talk to her, okay?
Disorderly?
Judge, that's your case. It's a BC.
See, that case doesn't even belong to me. I didn't.
Why did she sentence you then? Okay, my mistake. It did look like, all right, she sentenced him for some reason. That's fine.
Looks like at some point she may have arraigned him on a warrant.
I did not pick up a new case. I'm confused.
Okay.
Okay.
I got files all over the place here, Lisa. Thanks for keeping me on track. This was both from the offense date of August 6th of 20. They were concurrent. It looks like she would have taken the pleas on those, didn't she, Lisa? In July? Yeah, guilty plea. So they moved the sentence. So I'm going to sentence him in this other one too. So it looks like on the probation violation that applies to both the B and the C cases, she took them both, all those pleas back in July of 24. I'll just give you 1 second. July 16th of 24. So she took those pleas. She just marked them on one. So on the other one, probation's revoked. You owe 1314. You pay costs. I'll reduce those to 500 and serve 90 days, credit 18 for 72. If you pay costs of 500, I'll suspend 37 of the 72. You'll only have to serve 35. These will run concurrent. So you have your choice. If you do pay 1125, you're going to be out in 35 days. If you don't pay 1125, you're going to have to serve 72. Good luck. Wish you well. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I really wish you well, sir. I hope you get your life in order. Thank you very much.
Thank you. Thank you, Judge.
Thank you, Judge.
Until we have a problem with Mr. Walker. Christopher Raymond Walker, 25W727443. Wow. Your name?
Good morning, Your Honor. I'll give you a 5-0 Mr. Walker, who is to my right of second. Christopher Raymond Walker.
Illicit falsification, Your Honor.
I can't take his plea today. He blew a 198. I didn't realize. She said he reeked of alcohol. I can't smell him from here. What was it, Lisa or Beth? How much?
He blew a .198 in my office.
So, counsel, I think we need to have him withdraw the plea, and then I'll reschedule this.
Can I speak for myself, Your Honor?
If I were you, I'd look at the floor. I wouldn't say a word. Okay? You got a big problem with me now. So I just want to be clear, counsel, you agree on that the plea should be withdrawn and just enter a not guilty plea and adjourn it. I'm going to set a bond and I'm not going to have this sentence stay in effect. You agree that the plea should be withdrawn?
Yes, Your Honor.
Wow. I'm never amazed. I'm just never amazed. You're here with the 2-0 and don't say a word. You shouldn't say a word. I don't want you to incriminate. You shouldn't say a word. You're here with a 2-0 at roughly 11 o'clock, which means you were either pounding something heavy before you came this morning, or you were up until 1 or 2 in the morning drinking, in which case it's alcohol dissipates at the rate of 125 an hour. You had to be over a 3-0. And now you want to talk? I'll indicate for the record, per defendant, plea withdrawn, sentence withdrawn. Where does he work at, counsel? Sentence held for naught, I should say. Where does he work at?
He works for a car dealership and he's trying to get a new job at this time.
Lisa, I want to, Lisa, jeez, Pete. I want him sent to, I don't even trust that he will go get a sober link on his own. I'm going to set a bond of $10,000, 10%. He's not to be released until fitted with a sober link device, and he's not to be released until his BAC is .02 or less. So Woodhaven's going to have to take him over there. Not to be released until BAC .02 or less, not to be released until fitted with a sober link. So you're going to have to post the bond, and hopefully they will help get you fitted with a sober link ASAP. And hopefully, if you can post, you should be out of there. But I don't know how quickly. I just can't trust somebody I just told to get a sober link by the end of the day isn't going to be driving around town. So that's all I can do, guys. Thank you. That's all I'm going to do. Thanks.
Thank you.
And we're going to give a new date. Lisa, what will be the new date? I'm going to have you write it in there. You tell me the
June 24th at 8:45.
24th at 8:45. Can you write it on the file, Lisa?
Yeah, I'll write it.
June 24th at 8:45. I have Ashley Nicole Hansard. Is this the other one?
I have Ford, Hansler, and
5125R 513992.
More.
Who's your lawyer, man? Oh, I'm sorry.
I didn't hear you call the case, sorry.
That's okay. Okay, so your name on
Ashley Nicole Hansler.
counsel, what's she going to do?
We are asking for a hearing, Your Honor.
All right, raise your,
Oh, I was gonna say, I was gonna motion dismiss count one. I realized that was an error in my end.
okay. Count one dismissed. Motion of PO. All right, do you still wish to proceed to the hearing on the others?
Yes, Your Honor.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Go ahead.
Since I issued, at the time that I issued the violation on June 10th, I didn't have any, proof of her community service. I received it via email today. It's dated April 26th, but she did complete the 24 hours of community service.
That was supposed to be done on April 15th, right?
Correct.
Okay, go ahead.
And then as far as the treatment goes, I guess I can motion to dismiss that as well. I received it May 29th, but it went to my spam, but I do have proof now that she did her intake appointment on May 22nd.
I'm losing it here. You're dismissing count?
Yeah, I'll dismiss the treatment.
Wait a minute. The treatment one is count 6.
Yeah, I just realized when reading this email, they sent me proof on May 29th, but it went to my spam folder, so I didn't have it on June 10th, so that would be my fault.
Okay, good enough. What else? She didn't provide proof of community service completion by April 15th, correct?
She did not.
She didn't pay her fines and costs as ordered?
Her payment plan was,
$100, the date of sentence, 100 monthly, beginning on the 10th of March.
yeah, she did, yeah.
And what about failure to submit the biweekly testing on April 7th?
She did not submit that.
And what about attending AA once a week?
I would need proof February 20th to her intake appointment, May 22nd, and I have not received it.
Okay, so she's got, well, I know, but you can't do everything months late, ma'am. You know what I'm saying? We're not gonna go chase you around.
I get it.
All right, so you can address, I'm dismissing counts 1 and 6. You can address counts 2 through 5. Do you have any questions of her, Mr. Nahikian?
Yeah, just 1 second.
Oh.
So, in relation to the payments, when were her last payments, or what ones was she not compliant on?
I'll be honest, you'd have to look it up. I don't have the ROE in front of me.
She paid $300 on May 21. I don't see where she paid anything before that.
Okay, so we essentially just paid us like
3 months.
12 staff meetings. Is that just something that she would provide, or is it supposed to be in the?
She's supposed to provide proof of that.
Yeah, I mean, given the 2 dismissals, Your Honor, I think that we would
All right, I'll just find guilty on counts 2 through 5. So I'm gonna make a note. Counts 1 through 6, 1 and 6 dismiss, motion to the probation officer. Please, or I'm gonna find her guilty as charged on counts 2 through 5. All right, do you want to say something here? Why is she being so incredibly aloof about all of this?
I don't know. Yes, she dismissed all.
The probation appointment wasn't miscommunication on my end. I looked through my email. I had rescheduled her and then we spoke on the phone and I forgot to schedule in the computer. So
That's all
my fault.
fine and
Yeah.
dandy. I'm fine. I get it. She didn't show up for her testing. She didn't pay her fines when she was supposed to. She,
Testing, 100% her fault. She did miss, that's on her. She messed up. The payment, she was late. I think she needs to make sure the court's aware of that. Again, that falls on us. For the AA, my only argument would be if she had that meeting, she could have provided it on that date. Obviously, there are other ways of providing it, but she intended to do it. She has the documentation to show that she has been doing this.
once a week?
Yes, Your Honor.
All right. Where's the community service completion?
That I have now.
It was just.
All right. Are you gonna start to do something here and grow up?
Yeah,
How old are you?
I'm 40.
All right. Well, come on. You got to be more diligent in getting in these things in timely. I told you if you didn't have the money, call the court. I'll give you an extension. Did I not say that?
Yes,
Then why didn't you do it?
just go behind. I have no excuse.
All right. Okay, here's what we're gonna do. I'm just gonna indicate, I'll keep you on probation. Serve 8 hours of community service. You do that in this case to be done by June the 27th. So I want you to get on that. I'm gonna assess costs. I'll only go $50. And we'll, all other terms and conditions to remain, but you gotta be a little bit more responsible.
I understand, thank you.
All right.
Can we address the new payment plan?
You guys figure out the payment plan. You sit and talk to her about a payment plan then, okay?
I'm sorry, Judge, what did you say the due date was for community service?
June 27th,
Thank you.
okay? Good luck, ma'am. Thank you.
Thank you.
Now I've got this gentleman out here. What in the world is he here on?
This is Mr. Moore.
Judge John gave me Mr. Horn's court file by accident. I think that.
Who's this guy out here?
That's Brandon Cole. They're both fine.
I need to meet with them. Before.
I get it. Take your time. I need to get off here for a few minutes.
Can we do Mr. Moore?
No. I need to get off here for a few minutes. I really do. Lisa, is Mr. Fowler out there?
Yes, he's been out there since 11.
Just tell him to be patient with me, will you please? It's been, all right, that's what we'll do. Thank you. Stay seated, everybody.
If I'm reading this right, it says this guy needs an attorney.
We did this one.
Oh, you did?
This was just something.
Okay, so I was out first. I think this guy's one of those. Yeah. What does that need here?
This is the work on plan.
I think so, no.
I just didn't know.
Until she's fully released.
Yeah, no, the answer is no.
That's fine.
Okay, all right, have a seat. Yes.
Judge, what do you want her monitored? Do you want house arrest?
She's on house arrest, yeah. Case number 23CR40547, the State of Ohio versus Clint Irvin. Mr. Irvin, the court has received a report It alleges that you have violated the terms of your community control. Officer, statement of that allegation, please.
The allegations are the defendant violated general condition number 5 on April 4th, 2025. The defendant failed to appear for a probation review hearing, resulting in a warrant being issued. And special condition number 15D, as of June 6, 2025, the defendant has failed to make full and on-time payments towards his court-ordered child support.
All right, Mr. Irvin, do you understand those allegations?
Yes, sir.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
I'll waive right, counsel.
It's very likely you're going to prison. I said at the time I sentenced you that this.
Where is Henry been? I've been talking to him, but he hasn't been in
Mr. Henry
contact
is
with you.
Mr. Henry's out on a medical leave right now. He's not here. Tell me what, you want an attorney first? You want to talk to an attorney? Because I'm telling you right now, based on my notes, how much has he paid since I sentenced him in December?
He's paid nothing.
You're going to prison. You want to talk to an attorney? Those are your options right now. I'm not fooling around with you, Mr. Irvin. I ordered you to do something and you didn't do it. You have a horrible record. I said at your sentencing, this was the only chance you had. So it's now been 6 months and you've paid nothing? That's not acceptable. So, you want to talk to an attorney?
Yes, Your Honor.
Okay, do you have the funds to hire one?
No, Your Honor.
All right. Mr. Logs is going to hand you a form. It's an affidavit of indigency that you need to sign for me, please. All right, the court will find that you are indigent for the purposes of retaining counsel, and I will appoint Attorney Todd Williams to represent you in this matter. The court finds that there's probable cause you have violated the terms of your community control. This matter will be set for final hearing. You'll be held in Warren County Jail pending that final hearing.
Does this matter if this was my previous attorney?
I don't know.
It was my previous
Is it?
attorney.
Yes. Yes, it is. Thank you, sir. Have a seat. Smitty? This is case number 23CR41199, the State of Ohio versus Kathy Smitty. Ms. Smitty, the court has received a report that alleges that you have violated the terms of your ILC. Officer, a statement of that allegation, please.
The allegations are the defendant violated ILC condition number 5 and failed to report into the office for an office visit on June 18th, 2024, as well as for an order to report on July 12th, 2024, which resulted in a warrant being issued for her arrest. Violated special condition number 16B. To date, the defendant has not provided verification that she is engaged in or has successfully completed outpatient treatment. Violated special condition number 16C. To date, the defendant has not provided verification that she is engaged in or has successfully completed outpatient treatment. And to date, the defendant has not completed thinking for a change.
All right, Ms. Smitty, do you understand those allegations?
Not really.
All right, they're saying you didn't report when you were ordered to into probation. They're saying you haven't engaged in treatment or haven't provided verification that you've engaged in treatment, and that you haven't done the thinking for a change course that was ordered by the court. Do you understand now?
I think so.
All right, you have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
No.
You want me to appoint you one?
Yes, please.
All right, Mr. Loxton's handing you a form. It's an affidavit of indigency that you need to sign for me, please.
Is there any way I can get out? I'm getting evicted and I'm gonna lose everything I own if I don't get out and get, I was in the process of packing up my stuff. The reason I didn't go to meet them, my car broke down. and I
Now's not
was-
the time to discuss this, ma'am.
Sorry, sir.
That's okay.
My mother was real ill and I was taking care of her and I couldn't
Again,
get-
Ms. Smitty, you need to talk to your attorney because you might be saying something that could be
I'm
used
sorry.
against you at a final hearing.
Is there any way I can get out today?
The recommendation is that you remain in custody until a final probation violation hearing is set.
When will that be? I won't lose everything I own.
All right. Court will find that the defendant is indigent for the purposes of retaining counsel, and I'll appoint Attorney Jonathan Gibbs to represent you in this matter. The court finds that there's probable cause you have violated the terms of your ILC, and this matter will be set for final hearing. We're going to hold you in the Warren County Jail pending that final hearing. All right, have a seat. Ms. Conklin? This is case number 24CR42106, the State of Ohio versus Elizabeth Conklin. Ms. Conklin, the court has received a report that alleges that you have violated the terms of your community control. Officer, statement of the allegation, please.
The allegations are the defendant violated general condition number 5 and failed to complete the STAR program as ordered.
Ms. Conklin, do you understand?
Yes.
Do you refuse to go to STAR?
Yeah.
Why?
Because.
All right, stop there. You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
No.
You want me to appoint you one?
Yes, please.
All right. This is just an affidavit of indigency that I need you to sign for me, please. All right, the court will find that you are indigent for the purposes of retaining counsel, and I will appoint Attorney Dan Getty to represent you in this matter. The court finds that there's probable cause you have violated the terms of your community control, and this matter will be set for final hearing. You'll be held in the Warren County Jail pending that final hearing. Thank you.
Thank you.
Bell?
Thank you, Your Honor. We're here today in the state of Ohio versus Jennifer Reese in two different case numbers, first being 25 CR 663 and the second being 24 CR 1461. That 24 case, we're here for probation violation. In the 2025 case, we're here for an information hearing where it's the state's understanding the defendant is going to waive her right to have her case presented to the grand jury and enter a guilty plea to count 1 of the information, that being possession of cocaine, a felony of the 5th degree with forfeiture specification. There is no agreement as to sentencing in this case. Thank you.
All right, Ms. Tomczyk?
Thank you, Your Honor. That is all accurate. And then with regards to the 24 case, Ms. Reese is planning to enter guilty pleas on that. And since she recently completed a pre-sentence report, Ms. Reese is willing to waive that and proceed with sentencing today.
All right, so the violations on the 24 case for the final hearing, March 26, urine sample positive for fentanyl. You understand that charge?
Yes, Your Honor.
And also May 5th, charged with this new offense, possession of cocaine. You understand that charge?
Yes, Your Honor.
All right, and what is your plea then to those charges?
Guilty.
All right, I'll accept your guilty plea and find you guilty. And so you're going to plead guilty today on the new case also? Is that correct?
Yes, Your Honor.
And then you're going to waive your right to a pre-sentence report, is that correct?
Yes, Your Honor.
All right. All right, how old are you?
I'm 38,
And how far did you go through school?
11th grade.
Are you a U.S. citizen?
Yes, Your Honor.
Are you able to read, write, and understand the English language?
Yes, Your Honor.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication in the last 48 hours?
Yes, Your Honor.
What have you taken?
Paxil and Clonidine,
And when did you take it last?
like 6:30 this morning.
Do those medications affect your ability to understand what's going on here?
No, Your Honor.
All right, did you get a copy of the information filed in this case?
Yes, Your Honor.
All right, it's one count of possession of cocaine, is that correct?
Yes, Your Honor.
So you're going to plead guilty to that and to the forfeiture specification, is that accurate?
Yes, Your Honor.
I understand you have the right to have your case presented to the grand jury for them to decide whether or not to indict you.
Yes, Your Honor.
Did you discuss that right with your attorney?
Yes, Your
And
Honor.
are you going to waive that right?
Yes, Your Honor.
Your Honor, Ms. Reese and myself have signed the waiver of indictment.
Your Honor, I witnessed the defendant sign a waiver of indictment, and I signed the same.
All right, I'll accept the waiver of indictment. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, or you want to talk some more to Ms. Tomaszek, let me know and I'll give you more time. You understand that?
Yes, Your Honor.
You have a constitutional right to have a trial either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand that the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of these rights?
No, Your Honor.
You still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Your Honor.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I can sentence you to prison, to jail, or to community control?
Yes, Your Honor.
And in this case, possession of cocaine is a felony 5. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, Your Honor.
And if you plead guilty to the forfeiture specification, then you're voluntarily giving up any right you would have to the items listed. Do you understand that?
Yes, Your Honor.
All right. Do you understand that your guilty plea may result in a driver's license suspension of between 6 months and 5 years?
Yes, Your Honor.
You understand your felony conviction prevents you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand that if a prison sentence is imposed in this case, that you might have to serve a period of post-release control for up to 2 years under the parole authority.
Yes, Your Honor.
If you are placed on post-release control and violate any conditions, parole authority could send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If that violation is a new felony, then you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, Your Honor.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, Your Honor.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, Your Honor.
Now, has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No, Your Honor.
Has anybody promised you what I will sentence you to in this case?
No, Your Honor.
You understand I don't have to follow the sentencing recommendation of either the prosecutor or your attorney?
Yes, Your Honor.
Have you had enough time to talk with Ms. Tomaszek before pleading guilty today?
Yes, Your Honor.
Has she discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice she has given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
All right. Ms. Bell, if the case went to trial, what would the evidence show?
Thank you, Your Honor. How this matter proceeded to trial, the state would proven beyond a reasonable doubt that on March 26, 2025, in the Lake County Jail that's in Painesville, Lake County, Ohio, the defendant was found to be in possession of drugs, and she admitted being in possession of those suspected narcotics. They were sent to Lake County Crime Lab and confirmed to be positive for cocaine, a Schedule II drug, and for purposes of the forfeiture specification, they also tested positive for fentanyl and heroin. Thank you.
Thank you. Ms. Thomas, is there anything to add to those facts?
Nothing on the facts, Your Honor.
All right, Ms. Reese, did you hear what Ms. Bell said, that the facts would show if the case went to trial?
Yes, Your Honor.
And are those facts true?
Yes, Your Honor.
What is your plea to possession of cocaine, a felony 5?
Guilty.
And what is your plea to the forfeiture specification?
Guilty.
All right, Ms. Thomas? We have her initial in the margin on page 2. Madam Bell, do you know how many days she has in jail on this?
Let me confer with Ms. Weehagen.
Do you know, Megan?
I have the credit calculated for the violation piece.
How much?
77 days
That's just on this?
on
On the violation?
And then on the 25 case, she was booked in on 5/5. I don't know if that makes sense.
26 and 10, 36.
Your Honor, Ms. Reese has signed the written plea of guilty and I have signed.
Makes it tough when you're banked and you have to keep track of what's in the bank.
Your Honor, I witnessed the defendant sign the written plea of guilty. Ms.
As
Thomas
opposed to
and I signed
unbanked.
the same.
Right. All right. Ms. Reese, is this your signature on the written plea of guilty?
Yes, Your Honor.
Did you sign it voluntarily?
Yes, Your Honor.
And do you want me to accept your written plea of guilty?
Yes, Your Honor.
I'll accept the written plea of guilty. Defendant was present. Ms. Tomaszek advised of all of her rights, being a knowing, intelligent, voluntary waiver. She understands the nature of the charge, the consequence of a guilty plea, and the maximum penalty. Found to be knowing, intelligent, and voluntary, will accept the plea of guilty and find her guilty of possession of cocaine, a felony 5, and the specification. And Ms. Reese has indicated she's going to waive a right to a pre-sentence report. Are we ready to proceed to sentencing?
Yes, Your Honor.
Ms. Bell?
Yes, Your Honor.
All right. Ms. Thomas, go ahead.
Thank you, Your Honor. We would just like to ask the court on the 24 case to allow Ms. Reese to continue probation, and then on a new case, give her an opportunity at probation. And speaking with Ms. Reese, she indicated to me she wants to do the jail treatment program. She thinks she would greatly benefit from that. She does have a plan in place for herself. She wants to do the jail treatment program, and then when she gets released, if she gets released from there, she would like to do residential treatment and then do sober living. So she does have a plan in place. She wants to stay in a sober environment, remain in a sober environment, and get fully sober before being released from any sort of residential. and speak with Ms. Reese. She indicated to me her daughter is graduating high school next year. She wants to be there for her daughter. She wants to be sober for her daughter. She wants to witness her graduate. She does have a friend that she is able to stay with. It is a sober environment, so if Your Honor allows her the chance to do jail treatment, do residential, she will have a sober place to live. After all of this, it is currently where her daughter is living as well. Thank you.
Ms. Reese, what do you want to tell me?
I have been thinking about this for a very long time, and I don't want to sit here and say I can do this, because obviously I can't do this on my own anymore. And in order for me to get clean and stay clean, and I know I can because I've done it before, I definitely need the treatment in order to do it.
Well, what happened last time when we were here and you were supposed to go to treatment? What'd you do? We were here 2/19 at 25, and you were supposed to do an IOP at Lake Geauga.
I kept pushing it off and pushing it off.
Why?
Well, at first I wanted to do Signature Health, but Signature Health had a wait list. So then I got involved with Lake Geauga, but it wasn't working around my schedule between work and stuff like that. So I was trying to figure out how to get into Signature Health as soon as possible. And then I relapsed.
Where were you working?
Through Minutemen. It was a paper company out in Willoughby.
All
Off
right,
of
you
Euclid
can't,
Ave.
I mean, your problem is you're kind of doing it backwards. You gotta address
Yes.
your drug problem before you address your employment problem.
Yes.
Okay? When was the last time you had a mental health evaluation?
It's been a few years.
Okay, what diagnoses do you have? in the past?
Bipolar, depression, and anxiety.
All right, how have you treated those things?
When I'm clean, I'm on my meds.
And what meds are you generally on?
Abilify, Clonidine, and now Paxil.
Okay, so what happens that drives you off of the meds?
The people that I hang out with,
Okay,
and
so is
being here.
it you start doing the illicit drugs while you're on meds and then you stop taking the meds, or do you stop taking the meds and that drives you to do the drugs?
I stopped taking my meds.
Okay, it's gonna work both ways, right?
Mm-hmm.
So you're clearly aware, now that you've been sitting here for, is it 77 days?
Yes, Your Honor.
Okay, that works exactly 0% of the time, right?
Mm-hmm.
Because you understand why you're on the mental health meds, right?
Yes.
And when you're on them, how do they work?
They work perfect. I get up and go to work. I do what I'm supposed to do. I'm ambitious. I want to do things. I'm more involved in my kids' lives.
Where does is it your daughter's the youngest?
Yes, Your Honor.
Where does she live?
She lives with her friend, Haley. Her mom's name is Tammy How do you say it? It's C-A-R-M-A-K. Carmack.
What's her first name?
Tammy.
Okay. Do you have a license?
No, Your Honor.
All right. Ms. Bell?
Thank you, Your Honor. We were here, very recently, earlier this year for Ms. Reese's previous case, so it's disappointing that we're here again. However, the state is not asking for prison in this case. However, the state would ask for a higher level of treatment, either that being a JTP or NeoCap or both. Thank you.
All right. I've gone back and looked at the old pre-sentence report and listened, everybody considered all the provisions and the applicable statutes. I'm going to put you on community control for 4 years. So that'll be on the new case, and I'm going to extend your community control on the old case to June 10th of 29. So 4 years for both cases. And on the old case, you're going to spend 77 days in jail with credit for the 77. On a new case, you're going to spend 71 days in the jail with credit for 36. The last 30 days, you'll be in the jail treatment program. You'll complete that and follow the recommendations. Then after that, you'll go to Oak House. You'll complete that program and follow those recommendations. Then, then you'll go to Sober Living for a period of at least 6 months and abide by those rules. You're going to get a mental health evaluation, follow those recommendations. You're to see only one doctor, one dentist, and one pharmacy for any prescription medication. You're to take your medication as it's prescribed, sign releases for probation. At the appropriate time, obtain and maintain full employment, get a valid driver's license, and pay the cost and supervision fees. Who prescribed the medication you're on right now?
I just know her first name. Her name is Kim through Crossroads.
Okay. All right. So it's up to you where you get that evaluation, but you got to get it.
Okay.
All right. If you need another doctor for any reason, you just keep probation informed, because we don't want you going to a bunch of doctors we don't know about and getting medication you shouldn't be getting. Okay. Any question about, Ms. Hagan, any other terms?
No, Your Honor, just the old case, is probation extended to the prior conditions?
That's the old case will extend it to June 10th of 29, and all the conditions, with the exception of the time in jail, all the conditions on the new case are now the conditions on the old case. Okay. Any question about the terms?
No, Your Honor.
All right. If you violate, the state will file a motion to terminate your community control. If that finds you violated, then on the new case, you're looking at 12 months. On the old case, you're looking at 12 months. You understand that?
Yes, Your Honor.
All right. Anything else?
Just the forfeiture, Your Honor.
Forfeited. Anything else, Ms. Tomaszek?
Nothing further, Your Honor.
All right. There comes a time when it's either is going to work or it ain't going to work, right? Now's the time.
Yes.
Senior, case number 25 CR 629. Mr. Molnar is in court today with his attorney, Mr. Bill Watson. Defendant was indicted on one count, Your Honor, that being failure to comply with the order or signal of a police officer, a felony 3 in violation of 2921.331B. That indictment was filed on June 6th of this year. Discovery was sent just yesterday, Your Honor. The state understands that after arraignment, the defendant would be actually prepared to withdraw his previously entered plea of not guilty and instead plead guilty to the indictment. There is no agreement as to sentencing, Your Honor. Thank you.
All right, Mr. Watson.
Thank you, Your Honor. May it please the court, that's my understanding of this morning's hearing. I do believe full discovery has been provided. I have had an opportunity to talk to Mr. Molnar about this. He has indicated to me that that is his desire to enter a change of plea. He understands that by doing so, he'll be waiving certain constitutional rights, and no threats or promises have been made in order for him to do so. With regards to the arraignment, Your Honor, my client has had his indictment for more than 24 hours. Will waive any service defects, waive any reading of it, and like to enter a plea of not guilty at this time to the indictment. Thank you, Your Honor.
All right, not guilty plea will be entered. Mr. Molnar,
Yes, Your Honor.
Mr. Watson indicates to me that you would like to change your plea and enter a plea of guilty to the charge in the indictment. Is that accurate?
Yes, Your Honor.
All right, then, before I accept the guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. So I'm going to ask you some questions. If you don't understand a question, or you want to talk some more to Mr. Watson, let me know and I'll give you more time. You understand that?
Yes, Your Honor.
All right, you have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine those witnesses. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, Your Honor.
Are you waiving that right?
Yes, Your Honor.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you could not afford to hire a lawyer, one will be provided at no cost. Do you understand that?
Yes, Your Honor.
If you file an appeal, you're entitled to get a transcript of all the hearings in this case. Do you understand that right?
Yes, Your
Are
Honor.
you waiving that right?
Yes, Your Honor.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, Your Honor.
If you plead guilty here today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, Your Honor.
Do you have any questions about any of your rights?
No, Your Honor.
You still want to plead guilty to this charge?
Yes, Your Honor.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, Your Honor.
You understand by pleading guilty to this felony that you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, Your Honor.
The charge of failure to comply with the order or signal of a police officer is a felony of the third degree, carries a maximum 36-month prison sentence and a maximum $10,000 fine. Do you understand that?
Yes, Your Honor.
There is also a mandatory license suspension. Is it 3 to life, Mr. DeMonte?
That's my understanding, Your Honor, yes.
A mandatory license suspension of at least 3 years up to your lifetime. Do you understand that?
Yes, Your Honor.
Are you currently on post-release control to the parole authority?
No, Your Honor.
All right, do you understand that your felony conviction will prevent you from owning or possessing a firearm?
Yes, Your Honor.
Do you understand that if a prison term is imposed in this case, and when you get out as part of your sentence, you'll be placed on post-release control for at least 1 year up to 3 years under the parole authority?
Yes, Your Honor.
They would place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, Your Honor.
If the violation is a new felony, then you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, Your Honor.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months of the time left under post-release control. Do you understand that?
Yes, Your Honor.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, Your Honor.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 36 months. Do you understand that?
Yes, Your Honor.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
Yes, Your Honor.
No, I'm sorry. No,
Has anybody promised you what I will sentence you to in this case?
no, Your Honor.
Do you understand I don't have to follow the sentencing recommendation of either the prosecutor or your lawyer?
Yes, Your Honor.
Have you had enough time to talk with Mr. Watson before pleading guilty today?
Yes, Your Honor.
Has he discussed everything about your case and answered all of your questions?
Yes, Your Honor.
Are you satisfied with the advice he's given you?
Yes, Your Honor.
Have you been threatened or coerced in any way to plead guilty today?
No, Your Honor.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
And Mr. Tavanchi, if the case went to trial, what would the evidence show?
Yes, Your Honor. The state would show that on June 27th of 2024, Willoughby Hills police officers responded to a flock hit. That was a flock hit that indicated that the defendant's vehicle was in their city. The defendant was wanted for a probation violation out of Geauga County, therefore the flock hit. When the officer responded to the area, he did see the defendant's vehicle parked at a Sheetz gas station in Lake County, Ohio. The officer saw the defendant walk out of the gas station, get into the car, and then proceed to drive out through the driveway of the parking lot. The officer was sitting in his marked cruiser facing directly into the driveway where the defendant was actually starting to exit. It was dark out. At that point, as the defendant was exiting in his car, the officer hit his overhead lights. The defendant paused and then turned and then took off out of the driveway, a different driveway, Your Honor, and at the same time ran a stop sign, sped down Chardon Road, accelerating very quickly, hitting speeds of some 73 miles an hour. I believe it was a 25-mile-per-hour speed limit there. It may have been 35, but at least twice the speed limit, Your Honor. The defendant at times ran yellow flashing lights at high speeds, sped through center lanes that are used for turning, sometimes splitting traffic doing that, also crossing intersections with yellow lights through the turning lanes. He even passed an officer who had been parked on the side of the road ahead of him, whose officer's cruiser lights were flashing. He was intending to deploy spike strips, but he was not able to do that because the defendant drove away too quickly. The defendant eventually was able to get away. The officers decided it was too dangerous to pursue. The defendant was eventually identified through video footage inside the gas station, as well as the markings on his own car. That is a license plate. Thank you.
All right. Mr. Watson, anything to add to the facts?
No, Your Honor.
Mr. Molnar, did you hear what Mr. Tavanchi said, that the facts would show if the case went to a trial?
Yes, Your Honor.
And are those facts true?
Yes, Your Honor.
All right, what's your plea to failure to comply with the order or signal of the police officer, the felony 3?
Guilty, Your Honor.
All right, Mr. Watson?
This is just what I went over with, the same thing. No changes to me, okay? Except that you are a citizen of the United States. So you just sign your name here. Today is 6/10/25.
Your Honor, I've witnessed the defendant and counsel sign the plea docs. My signature is there as well. Correct, Your Honor?
Mr. Molnar, is this your signature on the written plea of guilty?
Yes, Your Honor.
And did you sign it voluntarily?
Yes, Your Honor.
And do you want me to accept your written plea of guilty?
Yes, Your Honor.
And I'll accept the written plea of guilty. Defendant was present. Mr. Watson advised of all of his rights, made a knowing, intelligent, and voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty, finding to be knowing, intelligent, and voluntary. I will accept this plea of guilty and find him guilty of failure to comply, a felony 3. I'm going to refer this for a pre-sentence report. And the psychological evaluation sentencing will be July 23, 2:30. And at this point, I'm going to revoke the bond, but Mr. Watson, if something changes, then you can let me know that.
Understood, Your Honor.
All right, anything else, Mr. Devanche?
Nothing from the state, thank you, Your
Mr.
Honor.
Watson?
Nothing further, Your
All
Honor.
right.
All right.
On records and
and I haven't been able to pay because I haven't been able to. I've been trying to get a job. I've been filling out job applications, but it's been unsuccessful. I didn't realize catching an assault with a deadly weapon would make everything really, really difficult to get a job. No excuse though, but I've been actively pursuing jobs.
I don't know why you didn't show up here though for 2 years. I hate that. Especially after what we tried to do for you.
I was incarcerated from November 27th, 2023 till September 10th of 2024 in Wayne County Jail because I caught a case and a bunch of cases, and then there's a global resolution for that. And yeah.
Probation's revoked, pay cost of 1,000, serve for 50 days, credit 1 for 49. If you pay 1,000, I'll suspend 28. 28 of the 49, and you'll only have to serve 21. That's the best I'm gonna do. I hope you can come up with 1,000. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I wish you well, I really do. Good luck. I hope you straighten your life out. I wish you would have let us help you. Thank you.
You're welcome. Is it rank concurrent, Your Honor? Sorry, I apologize.
What's sentencing?
PSI.
Well, I just ordered an updated PSI. I'm just sentencing on the probation violation is all I'm doing.
Understood.
I just wanted to know what he's been up to since then.
Understood.
Okay? Thanks a lot. Do I have any more with you today? Thank you very much. Good to see you, Mr. Nahikian. We'll talk next week. How are you? Good. Good to see you.
I have good news. I have all of the here for camp time. I also understand that it's going to be a waiver and defense counsel here. One of them is to jump on Zoom, but you want to call it early?
I'm great with that. Give me the file, bring the lawyer in. I'll be glad to do that.
Anyone you want me to call? Thank you, Your Honor.
Hey, thank you. Good to see you, Mr. Nahikian. I appreciate your help.
I appreciate you. Thank you.
All right. Mr. Klingensmith has got to be in custody.
He's in the back, Judge. He's here.
Okay. Where's Johnny?
I'm not sure.
John, do you see John out there anywhere?
Let me check. I do not see him in the hallway.
I need to get Klingensmith out. It's going to be a waiver.
Okay.
And we're going to have them sign
They're all in the jury assembly room.
this form. So the defense lawyer would sign this, so I'm gonna open it up. You see where this is?
Yeah.
It'd be easier if you just pull that up. The defense lawyer, defendant, and the prosecutor have to sign that.
Okay, that's for Klingensmith.
Yeah, we're gonna waive it.
There's a defense lawyer over there.
Good afternoon.
Your Honor,
How are you?
I'm well, and yourself?
Good, thanks.
Good.
So it's gonna be a waiver?
Yes, Judge.
Okay, so you can sign it. We'll get your client in here and we'll take the waiver and,
Thanks.
You're gonna sign there, he's gonna sign it, I'm gonna go get him.
Judge, bit of a weird defense attorney situation today. Mr. Schulman asked me to be here in person for the client's benefit. Mr. Schulman's going to appear on Zoom simultaneously. I'm just going to keep my mouth shut.
oh, okay, no problem. Good morning, Sergeant.
Hi, Judge, how you doing?
Busy day today.
Yeah,
Yeah. It's a good day.
I think
Everything's,
it's busy every day though.
yeah, but it's getting more busy. It's getting busier, I should say. It's been very busy lately. It's good. Right? I mean, I guess it means we got more issues going on than I would like, but
You're back on the civil docket this month, right?
I'm not doing criminal state. I'm doing signing on records and the civil, but this has still been, still got a lot of criminal, it seems like, you know, on misdemeanors.
Yeah.
Doing all the arraignments on the felonies. How you doing, Mr. Schulman? We're gonna get you out of here.
Awesome.
I got my court officer getting the defendant out. I have the prosecutor in here, your associate's in here. Are you working as an associate with him?
I don't know if he's going to admit to associating with me, Judge.
I'll admit to association, but not
That's a different pay raise.
That's right.
Oh, boy. And then I have my old, what do I want to call her? She made me her protege, right? Right?
Yeah.
I'm talking about you. I was your protege.
Me?
She's doing good, I hear. I hear good things about her. I'm glad to hear that.
Yeah.
I really am.
Sit right next to your attorney.
Very good things about you. So that's nice to hear.
How you doing today, Your Honor?
Not too bad. How about you?
All right.
I'm going to have Mr. Battersby. I'm going to call him Battersby because I went to law school with his uncle.
Okay.
And anyway, he's going to sign this form for me in here on behalf of you guys, right? Is that okay?
Yeah, please do.
Your Honor, and then I just have to put something on the record prior to
Yes.
continuing,
Prior, what?
to us continuing.
Yeah, I haven't even called the case, so give him a minute and we'll take that and we'll go from there. Thank you.
Okay. You're right here. Understanding you've got a right to appoint an attorney today, you got to court appointed attorney, if you can't afford one, that's us. You got a right to a preliminary examination, you're gonna waive that today. You voluntarily waive that right to an examination. Receiving notice of the charges. I told you about the chief of the charges. Right?
Yes, sir.
Okay, understand those rights?
Yes, sir.
Give me a signature right there.
I got where are you right now? You in federal court or where are you?
Yes. I'm right across the street. I stepped out of federal court. Yes, I have.
I want to come down and see the Criminal Justice Center. I haven't seen it yet.
Oh, yeah, yeah. You definitely should take a tour. You got to get adjusted to it. Took me a minute, but.
I know one or two people that work there.
Well, I might let you guys take me on a tour down. Okay. People against Robert Ray Klingensmith, 25B702750FY. Mr. Klingensmith, your name?
Robert Ray Klingensmith.
Mr. Schulman?
Good afternoon, Your Honor. For the record, Sanford Schulman, P43230, appearing on behalf and with Robert Ray Klingensmith. I'm on Zoom. I apprised Mr. Klingensmith of my conflict, and Kevin Wittenoff is in the courtroom standing in for me, and today's the time and date scheduled for the in-person preliminary exam.
Do you want to state an appearance?
Sure. Kevin Battersby Wittenoff, P85532, appearing with Mr. Schulman on behalf of Mr. Klingensmith, who stands to my right.
Jessica Davidoff for the people, P86743.
All right, so this is going to be a waiver, correct?
It is, Your Honor. My understanding is that the complainant, I think it's Amy Beatty and Autumn Ebernese, are present. The people are ready to proceed. The defense is ready to proceed. after discussions with the prosecutor, I believe they have filed an amended complaint. We acknowledge receipt of that, and she can put that on the record. And with that they are ready to proceed, and with the amended complaint, the defense is prepared to waive this preliminary exam.
Wait a minute, where's the amended
Your
complaint?
Honor, I have a copy in my hands if I could,
Okay, sure, hand it up. All right, so I really think we need to do a signing on record on this. I really do. If you're amending a complaint to add different counts and we haven't had the,
Yeah, we might have an arraignment.
I mean, I have to go through everything, and that's fine. Because you're adding several counts, right?
So, Your Honor, what I'm doing is that on the original complaint, I would be dismissing count 1, and then.
All right, let me pull it out first. All right, so you're dismissing count 1.
And then count 4 on the original complaint. On the new complaint, I moved the remaining charges up, and I've added 3 counts of criminal sexual conduct in the 3rd degree, verses 13 through 15. Well, 2 of them is did engage in sexual penetration, to wit, penis into genital opening, and then count 5 would be criminal sexual conduct in the 3rd degree, person 13 through 15, did engage in sexual penetration, to wit, fellatio.
Okay, so let's do this. I'm gonna take are you ready to do a swearing in, the signing on record?
I can do that, Your Honor. I have my original investigator's report.
Okay, let's do that. Come on up to the podium. I'm gonna do the signing on record. All you're doing then really is dismissing of the original complaint, count 1 and count 4, and then you're adding the counts you just referenced, correct?
Right, so that'd be 3 new charges.
Right. Sergeant, your name?
Detective Sergeant Morrison Brown.
Raise your right hand. Solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Okay, go ahead.
Information from this investigator's report was gathered by reviewing the reports of others, including police, in addition to Detective Sergeant Morrison's own investigation. In July of 2024, Amy B., the mother of the victim, contacted Brownstown PD after discovering that her juvenile daughter, victim Autumn Everins, has been sexually abused by her 42-year-old cousin, defendant Robert Ray Klingenschmidt, since the victim was 14 years of age. Kids Talk interviews conducted and disclosures by the victim revealed that the defendant, 42 years of age, took the victim's virginity when she was 14 years old, at his residence in Brownstown, which is 26241 Sibley Road, Brownstown Township, Lane County, Michigan, the venue of this incident. Sometime in late 2021, early 2022, the sexual relationship continued, and the victim eventually moved in with him for the remainder of the 2023 school year when she was 16 years of age. It was disclosed that the defendant had planned to have her move in with him, telling her that she could move in to his residence when she was 16 years old. She disclosed that the sexual relationship continued until she left Florida weeks prior to the report. She disclosed the sexual abuse to her sister, witness Brianna Everins, while visiting with her in Florida. The victim disclosed that there was sexual material sent and received via Facebook Messenger and specified that the defendant sent her nude photos of herself on the application. The defendant had been an authority figure in the victim's life since she was only a few years old. The victim and her mother had been close with the defendant, and it was learned that the victim resided with the defendant multiple times for extended periods of time since she was young. Witnesses and victim indicated that the defendant was a father figure to her and referred to her and introduced the victim as his quote-unquote daughter. Due to the disagreements at home in Monroe, witness B allowed her daughter to move in with the defendant because of her long-standing trust with him and because he was a father figure